don't think it's muted.
You're unmuted.
I turned my sound off on that. Why can't I hear anything?
She's not even in her chair.
It's too quiet. There's something wrong. It just said check in by chat. See, this knocking moves very swiftly. Am I checked in? It says don't check in unless your lawyer's there. Do they have me muted? I should hear them. My head's hot. better than yours. It said it right on the thing that you. Everybody's talking. I can't hear anything.
Good morning, Madam Clerk. May I check in for Jabari Black?
Yes, but check in is via chat, but I have you. Thank you.
Okay, I've checked in via chat as well. Thank you.
I know. He's what's his judge's name? Type that. Judge Chandra Baker. Yeah. Katie, come here quick.
Hi, I'm calling from Mark Doolin. He just wanted to let you know that it's Chandra Baker's courtroom. He just wanted you to know that it's Chandra Baker's courtroom and that he's on it right now. Okay, thank you.
What did he say?
He didn't know the change court.
What's he not- You know, red my face looks on the computer. charge this? Charges on the badge.
All right. Third Circuit Court for the now session, the Honorable Chandra W. Baker Robinson presiding. All parties on Zoom, please remain quiet. The clerk will begin to check everyone in.
Good morning. At this time, all devices should be muted. Only unmute when your case is called. I will let you know before I call your case. At that time, simply unmute and wait for me to call the case. Check-in is done via chat only, no yelling out. Only check in when all parties are ready. All parties is a defendant, defense attorney, and prosecution. At this time, parties on Nolden should be unmuted and waiting.
Is APA Rhonda Hadar there? That's her case.
She's not here, we're not ready.
Where is your prosecutor, Ms. Callahan?
No, let's see, Hader. She is not on this call right now.
Parties on Black.
Gregory Bulahanis on behalf of,
Wait.
Nevin.
Once I notify you, just unmute and wait for me to call the case, please.
thank you.
This is case number 22150. People of the state of Michigan versus Jabari Black. Scheduled pretrial. Appearances for the record, please.
Good morning, Your Honor.
Good people.
Good morning, Your Honor. Gregory Bulahanis on behalf of Jabari Black.
All right, good morning. Where's Mr. Black?
He's right here, Your Honor.
Mr. Black needs to state his name for the record.
Say your name.
Jabari Bomani Black.
All right, good morning.
Good
All
morning.
right, I'm showing that this is a pre-trial. I have in here that there was a cop that was filed. Is that correct?
Yes, Your Honor.
And I believe I did have that yesterday. And I believe I had an issue. Yes. All right, so the issue that we have with the comps is we always do verify the information. The number that was given to us to call, that my assistant called for, there was never an answer. There was no mailbox or messages. Well, the message was full, unable to request. So there's no way to verify this. I mean, it's interesting to me that Ford doesn't answer the phone. So either we need a human resource number or we need a check stub, one of the two. Because we can't verify this if nobody answers. I don't know what number was given to us, but it clearly was not for its human resource department. Okay, so that's where we are.
Your Honor, are you talking about the Human Resources Department for his employer?
Well, yeah, says he works for Ford, so what I'm saying is
Yes.
the number that was given to us, no one answers it. And mailbox for messages was full, unable to request anything. So I don't know who this number is for, but it's clearly not the HR department. So either we need to have a number that someone answers. I'm sure Ford Motor Company is still in business. So we need to have a number that somebody answers, or we need to have a check stub. Otherwise, his employment is not verified. So that's what we need.
We can,
I
we'll,
would
we
think
will
it's very
submit,
easy. I'm sorry, I would think it's very easy to just submit a check stub, right?
yeah, we will submit that, Your Honor.
All right, submit the check stub and then we'll come back and I'll give you an evaluation on cards at that time. New date. June, the first week of
And what day would that be, Your Honor?
July,
I will give it to you as soon as my clerk gives it to me.
July, right?
Okay, thank you.
July 11th,
July 11th?
yes.
Okay.
Is that good?
Your Honor, can we do it another day? I have an in-person restitution hearing in a court that morning. It'll take the whole morning.
All right, July 12th.
I have a settlement conference in circuit court, and then I have another pretrial.
June 22nd.
No, give me the first week of July. You said, oh, June 22nd? June 22nd. All right, we'll see everybody June 22nd.
Okay, I do have a couple of hearings that day, but I'll
Make it work,
check in
Counselor.
early.
Make it work, Counselor.
I'll make it work.
June 22nd.
Thank you.
Matter is completed.
Thank you.
Next.
Morgan, parties on Morgan.
That was first name.
Oh, I'm sorry. Travis.
Ready.
This is case number 223336. People of the state of Michigan versus Travis Morgan. Scheduled calendar conference. Appearances for the record, please.
And good morning, Anna Michael Tenier for the people.
Good morning, Emily Elijah on behalf of Mr. Morgan. My P number is 85039. Mr. Morgan, would you please introduce yourself to the judge and let her know that you're okay doing this via Zoom?
Hi, my name is Travis Morgan, and I'm okay with doing the Zoom.
Hi, good morning, Mr. Morgan and Ms. Elijah and Mr. Tenney. Good morning.
Good morning, Judge.
This is a calendar conference. Mr. Tenney, do you have an offer for Mr. Sitter?
Not yet, Judge. Miss Elijah did submit a gun board letter, and that's being reviewed right now. So hopefully the next week or two, I should have an answer.
All right, and when was your gun board letter submitted, Ms. Morgan?
My gun board letter was submitted on June 3rd.
All right, yes, we should have a decision. We already had one Wednesday, we're going into a second Wednesday. So let's do first week in July.
First week of July, we got July 5th.
July 5th.
That is, I'm going to be out of the office that day, Your Honor. I am available on the 6th.
July the 6th. July the 6th at 10 o'clock. And that's to find out, we need a gun board decision by that time, Mr. Tenney.
Yes, Judge.
Outside of that, there will be your final conference date is August 2nd. The exam was waived, is that correct, Ms. Elijah?
That's correct, Your Honor. I don't anticipate motions outside of.
All right, well then, all right, so your gun board letter, we should have a position on that by July 6th, but your final conference will be August 2nd. Maybe we can get it resolved prior to that. The court has signed all the respective paperwork and it will be sent to you by Madam Clerk. Anything further?
Nothing for the people.
Nothing from defense. Thank you.
All right, thank you. This matter is concluded.
You can sign off, Mr. Morgan.
Alrighty, thank you.
All right, I'm ready.
This is case number 21439, People of the State of Michigan versus Earl Williams, scheduled pretrial appearances for the record, please.
Good morning, Honor. Michael Tanner for the people.
Who's the defense counsel?
Arnie Chambers is defense counsel.
No, Mr. Miller.
Good morning, Your Honor. My apologies, my printer just started. J. Grant Miller, P58658 on behalf of Mr. Williams.
All right, good morning, Mr. Miller. Where's Mr. Williams?
His name appears on the screen, Your Honor.
Mr.
He's
Earl-
muted and his camera's off.
Mr. Earl Williams? We need you to unmute.
All right, hello.
Yes, Mr. Williams, we need you to turn your camera on. and say your name.
All right, hold on one second. Earl Williams for the record.
All right, you need to turn your camera on. Mr. Miller, you're the attorney on this because I have Arnie Chambers.
Your Honor, it came up and it lists me in Odyssey, but I'll be honest, I've never gotten any discovery on this. So if it's Mr. Chambers, that would make sense.
It's you, Mr. Miller. I have you.
Okay, then I just need to get discovery from Mr. Tinney, please.
Well, hold on, because the jury trial readiness form, did you go over this form, Mr. Tenney?
Yes, Judge. Michael Woodyard was the original attorney when this was turned in back last August. And then I can't remember the exact date, but at some point, Mr. Woodyard withdrew. Mr. Chambers was appointed. I actually just spoke with Mr. Chambers yesterday, so he's still under the belief that he's the attorney for this case. I don't remember when Mr. Miller was supposedly appointed.
I made the change. So Mr. Chambers is on this case. They removed Mr. Chambers.
It automatically put in there, that means they were added.
All right, well, we need to reach out to Mr. Chambers and see if.
The Ron looking for you.
All right, Mr. Williams, you're in court, okay?
I hear you.
I don't want you to just hear me. I want you to stop walking because you are in court. All right, so we need to get this attorney situation straightened out. Mr. Williams, when you were here the last time, did you talk to an attorney by the name of Arnie Chambers?
Arnie Chambers wasn't there the last time, remember? And you was gonna give me somebody new, but Arnie Chambers came back and then we had another court date and something about something wasn't ready or something or another. And then it was,
Never mind. You don't know, never mind.
no, this what happened. I did know.
All right, Mr. Williams, if you speak out of turn and you disrespect the court in that manner again, we're gonna have a problem and I might make you come down to Frank Murphy. Do you understand?
Yeah, I understand.
All right, so is it Arnie Chambers?
Yes.
All right, so as Mr. Tenney and I indicated previously, it was Mr. Michael Woodyard was on the case. And we ended up replacing Mr. Michael Woodyard with Mr. Arnie Chambers. Mr. Tenney, did Mr. Chambers get the discovery?
I believe so, 'cause again, we've talked about the case a few times, so as most
Alright.
recently as of yesterday.
My understanding is he's on his way on. Is he zooming in or he coming?
He's gonna log in right now.
All right. So when he logs in, all right, here he is now.
I'm removing Mr. Miller.
All right, Mr. Miller, you're free to go.
Thank you, Your Honor.
Oh, good morning, Mr. Chambers.
Good morning, Judge.
Okay, so you're on the Earl Williams matter, correct?
Correct, Judge.
All right, we just called it. Can you state your name for the record, please?
Arnie Chambers on behalf of Earl Williams.
All right. Now, where are we? Do you have all the discovery?
As far as I know, yes.
Mr. Penny, he has everything?
I believe so, Judge. The note I have is that everything was resent to him back in March.
Okay, all right. So originally this was on the jury trial readiness checklist, but then that was under a different attorney. And so now we're under Mr. Chambers. Have you had an opportunity to talk to Mr. Tenney about what the offer is in this matter?
I have, Judge, and I had a recent conversation with him, Judge. I don't believe there was ever a gun board letter submitted in this, and I had communication with Mr. Tenney about that possibility, of which I would like to pursue.
Okay, all right. The court will give you an opportunity to pursue a gun board as well as see what you can work out with respect to any type of resolution. When we come back, to let the court know where we are. Today is June the 14th, so I'll give you a couple weeks to get the gun board letter in.
Thank you.
I'll give you the June the 28th. And then we
Okay.
gotta give the gun board a couple weeks to look at it. So late July. We gotta try.
July.
Okay, July the 25th.
Okay,
That'd be July the 25th.
Judge, I'm in
July
Oregon.
25th at 9 o'clock.
Judge, I'm in Oregon on the 25th. I get back early morning of the 26th. Can we do maybe the 27th or 28th?
When do you leave?
When do I leave?
Yeah.
I leave the 21st.
The 20. July 20th?
I can do that.
Okay, July 20th at 10 o'clock.
Thank you.
Mr. Williams, that's your next court date.
All right.
This matter's concluded.
Thank you.
How you doing? Doolin, first name Mark Doolin. Please unmute.
Okay.
This is case number 223049. People of the state of Michigan versus Mark Doolin. Scheduled calendar conference. Appearances for the record, please.
Good morning, Your Honor. Jacob Bloomers, P77307 on behalf of the people.
Good morning, Your Honor. Stephen Barker, P360330 on behalf of the defendant.
Dr. Mr. Bloomers, where's Mr. Doolin?
He's with us, Your Honor.
Mr. Doolin, state your name
Yes.
for the record.
Mark
State your name
Doolin.
for the record. All right, good morning, Mr. Doolin. All
Morning.
right, this is a calendar conference. Mr. Bloomers, do we have an offer for Mr. Doolin to consider?
Your Honor, at this time, the offer would be to plead to count one, assault with intent to do great bodily harm. That would be with a sentence agreement of guidelines, along with no contact with the complaining witness, batters counseling, and then any restitution to be determined. And I have those guidelines scored at 0 to 9 months intermediate.
Okay, so probation. All right.
Yes,
defense,
Judge.
Is that the first time hearing that offer?
It is, Your Honor.
All right,
However,
that being the case, the court court is gonna give you some dates. I see that the exam was held. Is that correct?
That is correct, Your Honor.
The transcript is due in on June the 8th. So do you anticipate filing any motions, defense?
No, Your Honor, we expect to proceed directly to jury trial.
Oh, okay. Well, if that's the case, and you don't want to engage in any further negotiation, then I guess Mr. Bloomers can send you a jury trial readiness form to be completed. Mr. Bloomers, do you have a blank jury trial readiness form?
Yes, I do, Your Honor.
All right, please get that to defense counsel. You all can put both of your answers on it, and then we can come back and go over it. We can just do that on the final conference date, which is August the 2nd. If you work out something before then you can let the court know. Other than that, we'll see you back on August the 2nd, which is the final conference date with the jury.
Thank you, Your Honor.
Very good, Your Honor. Thank you.
Nothing further from the people.
Nothing further for the defense, Your Honor.
All right, Mr. Doolin, your next court date is August 2nd.
I understand, Your Honor.
All right, that's concluded. Can I get Mr. Gladney?
Parties on Kevin Gladney. They're pulling your, don't pull that up, Judge.
Okay.
They're gonna pull your parties on bail. Please unmute. Jennifer Bell. Are we ready on bail?
Ready, Your Honor.
Where's your client?
Your Honor, I believe my client is on Zoom right now. Jennifer Bell, Your Honor. I've actually recently retained into this matter, but she did contact me this morning indicating that she is on Zoom.
I am here.
Okay.
This is case number 223192 of the state of Michigan versus Jennifer Bell. Scheduled calendar conference. Appearances for the record, please.
Who's
Again, Your Honor,
who's the prosecution? Wait, Mr. Tinney somehow I put it out. He's coming back in.
Do you have that information behind that?
Oh.
Yeah.
Yeah.
Good morning, Your Honor.
Wait, just
Ms.
one
Bell,
second,
just-
Ms. Bell. Mr.
Stand by,
Tinney,
Ms.
are
Bell.
you on the bail matter?
I am, Judge. Sorry, some reason I got kicked out.
No problem. State your name for the record.
Morning, Your Honor. Michael Tierney for the people.
And again, Your Honor, Attorney Brent Jaffe, good morning to you and your staff on behalf of Jennifer Bell.
Okay, good morning. Ms. Bell, state your name for the record.
Good morning, Your Honor. My name is Jennifer Bell.
All right, good morning to you. This is a calendar conference. Mr. Tinney, do you have an offer for Ms. Bell to consider?
Judge, the offer at the district court was entry without permission and domestic violence. So that's still the offer at this time. So we'll leave it at that.
Okay. Hold on one, well, let me finish this, man. Oh, wait a minute. Okay, hold on one second. I've gotta, oh. Mr. Bloomers. Mr. Bloomers? Oh, wait a minute. Oh, this is Mr. Tinney. I'm sorry, Mr. Tinney.
Yes, Judge.
Are you aware of the victim on this case? Supposedly, someone told her to be, or him to be here today?
I was not aware of that. I'm not sure who. I only got the file the other day, so I didn't even get a chance to reach out to him yet.
All right. Who is the victim's advocate on the file?
Is Jeff D. I don't know his last name. It's one of the domestic violence advocates, so not one I work with a lot. But I can have that person reach out.
All right, because apparently the victim on this matter is trying to come into Frank Murphy. I have no clue why. Because nobody's indicated to us that the victim was supposed to be here, and it's not a trial date or anything.
Your Honor, if I may, when the court is ready.
Sure, go ahead.
Thank you, Your Honor. Again, so I'm actually newly retained on this case. I do anticipate getting the exam transcript, and also there's outstanding discovery that I intend on seeking. Now that I know that Mr. Tini is the prosecutor, I'm confident that I'll be able to get everything I need. But I guess if we could perhaps come back for another final conference date or another pretrial date, so that I can have a chance to get the additional discovery, including the body cam footage that was referenced in the paper discovery, and then also the preliminary examination transcript. So that's kind of my position today.
Preliminary exam transcript. This was waived.
Your Honor, the exam was held in Plymouth
That's
District
not
Court.
what's on the paperwork. That's not what's on the paperwork from the district court, Madam Clerk. Can you please? There's nothing in Odyssey saying it was held.
Wait a minute. Well, this bail,
The note on my file says it was held.
it doesn't, it says one was ordered. It doesn't, I'm assuming it was held. That's all it says. It doesn't
Why does
say-
my paperwork say waived?
Ms. Bell, the preliminary examination was conducted. Is that correct? When there's testimony in court in Plymouth?
All right,
Yes.
never mind. Madam Clerk has to change it.
Okay.
So when does it due? Your exam transcript is due on June 24th.
Okay.
All right, and so any motions you plan on filing need to be due, timestamp to file no later than July 26th.
Okay.
Do you plan on filing any, or you think you may?
Yeah, Your Honor, based on my conversations with my client, I do think that there are motions that I may be filing in this matter. Yes.
All right, then if that's the case, I'll give the people till August the 2nd to respond, and we'll have to move the final conference. So the final conference will then be on the next week. I'm gonna try. The final conference is gonna have to be
The last day before you- Oh, shit.
what day is the 6th?
No, that's the,
Oh, that's the Saturday.
fifth is Friday.
Okay. All right, so the people's response will be due in on August the 2nd. We'll have the final conference on August the 5th. Okay, hold on one second. Let me see what's going on with this. Mr. Tenney, did you email the victim's advocate? 'Cause, you know, I mean, I don't want to turn the person away, but they're not on the list to get in the building. And I don't know if someone told them to be here for a particular purpose, because at this point, they're not getting.
I did send an email to them. I don't know if they've had a chance to see it. I don't know. Not sure what their schedule is today. I don't know if they're in front of the computer or not.
Okay,
Oh.
hold on. All right, unless there's anything further. Let me ask this. You said that the current offer is what was offered at district court, which was DV and entering without permission. Is that correct, which is misdemeanor?
Correct.
So my understanding is when it's not taken at district court, that's no longer the offer when it comes to circuit court.
And there's nothing indicating that it's not, so they can only go what's on the file, Judge.
Okay, well, when we get you on the final conference, let us know what's going on with this offer. I mean, it's still here for right now, but it could be withdrawn by August 5th. So keep that in mind, council.
I appreciate that, Your Honor. And then as far as that final conference date, that's when the motions will be argued if they're submitted, timely filed, I guess.
Yes,
Okay,
the final
understood.
conference on August 5th.
Thank you, Your Honor.
All right, thank you. This matter is concluded. Ms. Bell, you can hang up.
Okay, thank you.
Have a good day.
You too.
Next.
I'm glad.
Glad.
You got that. That's what they wanted to say.
Glad. Kevin.
This is case number 216489. People of the state of Michigan versus Kevin Gladney. Here's a free trial. Genesis for the record.
Good morning, Your Honor. Erin Wilmoth, P82085, appearing on behalf of the people.
Good morning, Evan Callahan, P30564 on behalf of the defendant.
All right, good morning, Ms. Wilma and Mr. Callahan. Mr. Gladney, state your name for the record. Good morning, Mr. Gladney. All right, I have on here jury trial readiness form. Is that what we're doing?
Judge, I think we need a little bit more time.
Ms. Wilma?
Mr. Callahan and I are still in discussions, and there is some additional work that we are trying to effectuate, which is going to require some coordination with my officer in charge, who I did reach out to by phone, and I sent an email this morning while we were waiting. So if we could just have one final date to work that out, and then I think if we don't have it worked out, we will certainly be ready to go to trial.
Yes.
Okay. Yes, because this is a 21 case. We need to get it moving. Mr. Gladney been in. Which was.
Warrant was authorized March 29th of 2021, but this was not an in custody case. This is a case I inherited, so.
Well, DSU was done in October 2021, so I'm assuming it must have been around October.
What was the date you went into custody? 28th last year, Judge.
Yeah, so that's almost been a year. So yeah, we need to move. No, what we need to do is get this ready to go to trial. That's what we need to do. I think we dealt with fine issue before, haven't we? Yeah.
Yeah,
So no, what we
multiple
need
times
to
since
do-
I've been reassigned.
All right, so let's get this moving. So I'm gonna give you all a date, and it's not gonna be that far out. And we need a decision on that date. Otherwise, we need to get this, I'm giving it a trial date. I want to try before the end of this year, so.
And Your Honor, the people did file their witness list. I will note, I'm probably going to amend this because every single witness was endorsed, which I do not believe is necessary. So it has been filed, but I am going to file an amended one before the next hearing.
Okay, well, this is what I'm gonna tell you all. We're gonna come back on. We need to take the first week of July.
Around here.
Are you all here on July 5th?
I am.
Ms. Callahan?
Good on July 5th. Well, I don't know, that's not time, is it?
Today is only June the 14th. So that's 3 weeks from now.
Okay.
Yeah.
All right, July 5th, Judge.
Okay, so that's 3 weeks from today. We'll see you at July 5th on, at, let's say at 11 o'clock. At that time, if we do not have a resolution, please have the jury trial readiness form filled out along with all the supporting documentation that goes along with it. And we will be picking a trial date on that day, which will probably be sometime towards the end of the year.
Thank you, Judge.
Thank you, Your Honor.
All right, this matter is concluded.
Parties on William White.
I'm here.
I got Reno, Wall, Rico, Verde, Rico. William should be at the very end. It goes from Travis to Vincent. No, William White. And
Okay.
all right, you ready on William White?
This is case number 22539. People of the state of Michigan versus William White. Scheduled pre-trial. Appearances for the record. Ms. James, you're muted.
Good morning, Your Honor. Michael Tanner for the people.
And good morning, Your Honor. Nicole James appearing on behalf of William White, who is present via Zoom.
Okay.
William White.
Good morning, Ms. James, Mr. William White, state your name for the record.
William Austin White.
All right, Mr. White, you need to turn your camera on. All right, the last time we were here, I have a note on here that says drug court. Were we looking in the drug court?
Yes, Judge, and I reached out to Mr. Heaphy, who then had someone from drug court to contact me, but in his initial email right after court, he said it would take more than 2 or 3 days to do the assessment. But Mr. White, I emailed him this morning the documents that he needs to fill out so that he can be screened. So Mr. Heaphy didn't indicate how much time, but he said it would take more than the few days that turnaround that we had going on.
All right, I think I just want to find out if we could get it going. So we'll give you a date towards the, give me something in end of July or beginning of August. July the 25th?
That's a good day, Your Honor.
All right, good. We'll see everybody back on July the 25th at 9 o'clock.
Okay.
All right, this matter is concluded. Have a good day.
Have a good day, everyone.
Y'all at a standstill. Mr. Quinn, I see you, but you didn't check in. Who do you have? Are we ready on Virgo? You're breaking up. Did you say you were ready, Mr. Quinn?
Yes.
Parties on Imani Virgo, please unmute.
Oh, Virgo, as in E.
This is case number 211049. People of the state of Michigan versus Imani Virgo, scheduled sentencing. Appearances for the record, please.
Good morning, Your Honor. Michael Tanner for the people.
Good morning, Judge. Christopher Quinn, P69483, appearing on behalf of Ms. Barco, who's appearing via Zoom and consents to appearing via Zoom.
All right, good morning to Mr. Quinn. Ms. Vargo, please state your name for the record. Ms. Vargo?
Yes, ma'am.
All right, you need to state your name for the record. Good morning.
Hello,
Yes, you need to state your name for the record.
Imani Vargo.
Ms. Vargo, you need to turn your camera on. You're in court.
I can't, ma'am. My camera is broke.
All right, Mr. Quinn, do you state for the record that you are familiar with your client's voice and that is your client on this call?
Yes, Judge.
All right, this is the date and time and place set for sentencing in this matter. Ms. Vargo, do you consent to be sentenced over Zoom?
Yes.
All right, and the parties had an opportunity to review the pre-sentence investigation report.
Yes, Judge.
Yes, Judge.
All right, starting with the people, are there any additions, corrections, or deletions?
Judge, the only change I have is to the sentencing date. Just needs to reflect today's date.
All right, the court will make that change. Mr. Quinn, any additions, corrections, or deletions?
No, Judge.
All right, Ms. Vargo, did you have an opportunity to review the pre-sentence investigation report with your attorney, Mr. Quinn?
Yes, ma'am.
All right, is everything in the report true and accurate?
Yes, ma'am.
Okay, Mr. Tenney, anything you'd like to say before the court imposes sentence?
Judge, for plea agreement, we'll move to dismiss count one.
Okay, the court will dismiss count one. Anything else?
Ask that you follow the sentence agreement, Judge.
All right. Defendant, anything you'd like to say on behalf of your client?
No, Judge, just ask the court for all the sentence agreement, Judge.
Right. Ms. Vargo, anything you'd like to say before the court imposes sentence?
No, ma'am.
All right, Ms. Vargo, in your evaluation and plan, it indicated that you graduated from Oak Park. But they were not able to verify that. So you're gonna have to need to produce your high school diploma. Otherwise, you'll be responsible for obtaining your GED. But I'm assuming that you have it. Okay?
Yes, I do. Yes.
Okay, so just provide that to probation department. And then-
Okay.
So need to verify that. So the court will follow the sentence agreement and sentence Ms. Vargo to 1 year and 3 months. Ms. Vargo, you're 23 years old, and are you employed, Ms. Vargo?
No, not currently.
Do you live in the city of Detroit?
Yes, ma'am.
All right, I'm gonna have you contact Detroit at Works. Give you the phone number. Your attorney can take it down as well. Make sure both of you have it. Do you have something to write the phone number down with, Ms. Vargo?
One moment. Yes, ma'am, I do.
The number is 313-962.
Yes.
9675. Can you repeat that number back to me, Ms. Vargo?
313-962-9675.
Correct. It's Detroit at Works. From my understanding, they have a lot of grant money. So they can find employment for you, or they can pay you to be trained for other job opportunities. You have a son, is that correct?
Yes, ma'am.
All right, so you need to become employed, Ms. Vargo. When was the last time you were employed?
The last job I had as far as an actual job was when I graduated high school. I worked at the Holiday Inn, but I do hair and I was doing construction with my dad for some years. I just recently stopped within like this last year or so.
Okay, all right, well, let's try that. Do you have stable housing, Ms. Vargo?
Yes, ma'am.
Okay, All right, you must not use or possess alcoholic beverages or other intoxicants, and you must not enter bars or other places where the primary purpose is to serve alcoholic beverages or drinking on site. The last part it says unless the field agent gives you permission for your employment, but I'm striking that because I'm indicating that you cannot get employment where there's alcoholic beverages being sold. And reading in your evaluation plan, you have a history with substance abuse, alcohol, so we're not gonna do that. You must comply with requirements of alcohol testing as directed by the field agent. You must not attempt to submit any fraudulent or adulterated samples for testing. You must not hinder, obstruct, tamper, or otherwise interfere with the procedure. And you must present proper identification at the time of testing. You must comply with the requirements of drug testing as directed by the field agent. You must not attempt to submit any fraudulent or adulterated samples for testing. You must not hinder, obstruct, tamper, otherwise interfere with the testing. And you must present proper identification at the time of testing. You must not use or possess any controlled substance or drug paraphernalia unless prescribed by a licensed physician or be with anyone you know to possess these items. You must complete a substance abuse assessment when you are referred by the field agent. It says you must perform 30 hours of community service. I'll deal with that when I come back to the cost and fees. You must complete the CBT program. Ms. Schoen, good morning. Are you on the call? Ms. Schoen, are you
Yes.
with us?
Yes, I am. Good morning.
Good morning, Ms. Schoen. Ms. Schoen, what is the CBT program?
Cognitive behavioral therapy.
Oh, okay. All right. So you must complete that. You must obey all court orders. You must not engage in any assaultive, abusive, threatening, or intimidating behavior. You must not use any object as a weapon. You must not own, use, or have under your control, air control, a weapon of any type, or any imitation of a weapon. And you must not be in the company of anyone you know that possesses these items. You must submit to the search of your person and property, including but not limited to your vehicle, residence, and computer, without the need of a warrant. If the field agent has reasonable cause to believe you have items that violate the conditions of your probation. You must report any arrest or police contact, loss of employment, which at this point you're not employed, or change of residence to the field agent within 24 hours, weekends and holidays exempted. You must not drive a motor vehicle. You must make genuine efforts to find and maintain legitimate employment of a minimum of 30 hours per week, unless engaged in the alternative program that's approved by the field agent. And you must provide ongoing verification of employment or your alternative program to the field agent. And you shall not give reason to be terminated or voluntarily terminate your employment or alternative program unless you first obtain written permission from the field agent. State costs are in the amount of $100. Is that correct? I don't think so.
Yes, ma'am.
That should be $75. And your crime victims assessment should be in the amount of $53. And pursuant to statute, you must pay a supervision fee of $30 per month for each month of regular supervision. They have on here that your court cost should be $1,200. I am aware that you are unemployed. So what I'm going to indicate is that I'm going to waive those and find that you are unable to pay them at this time, okay? Ms.
Okay.
Margot,
Yes, ma'am.
there is a fine of $200 that's ordered by the court. And I think that's based on the charges here. And then your attorney was appointed, so there are $400 in attorney fees. What I'm gonna allow you to do is that 30 hours of community service. I'm sorry, you were retained?
I was retained, Judge.
Okay.
Yes.
So that's a mistake then on the front of the face sheet. No one pointed that out. All right, so we're gonna strike the $400 in attorney fees because your attorney was retained, and the court will make that change on the front of the face sheet. All right, so In order, since I waived the court cost, you will have to do the 30 hours of community service. That's in lieu of court cost.
Yes, ma'am.
Okay, so Ms. Fargo, if you do not have any more criminal contact, you get your community service done, become employed. You can and pay your, the other costs and fines that I gave you. You can petition the court to be off of probation halfway through your probation period. So right now you are 15 months of probation. So basically about 8, 9 months, you petition the court to be off. As long as you've gotten your community service done, you become employed and you pay the other smaller costs and fines, and you have not had any other criminal contact. Okay, Ms. Fargo?
Okay.
All right, it's my duty to advise you that you have a right to request leave to appeal from the Court of Appeals to appeal your plea and sentence. If you cannot afford an attorney, one will be appointed for you at public expense. Because we are on Zoom, the clerk will email the appellate rights form to your attorney, Mr. Quinn. Does Mr. Quinn have permission to initial the form indicating your receipt of the form?
One more time, ma'am.
Does Mr. Quinn have permission to initial the form for your appellate rights indicating you have received the form?
Yes, ma'am.
All right, that's the form you must file with the clerk of this court within 42 days of today's date. That's if you wish to appeal your conviction and sentence. All right, you have 2 misdemeanors, so I'm assuming you do not, but that's the form you must turn in. That form will be sent to Mr. Quinn. I'm also showing you have 3 days of jail credit. Is that correct?
Yes.
Okay. Ms. Vargo, you do need to call probation when you hang up from here. Let them know you've been sentenced today. And that phone number is 313-224-2600. Okay, Ms.
224.
Vargo?
You said 224-2600, right?
That is correct.
Okay.
All right, Ms. Vargo, I'm going to give you a review date to come back to the court, at which time I will check up on you to make sure that you are fulfilling what I've asked you to do while you're on probation, especially getting a job. Okay?
Yes, ma'am.
I want you to come back in 3 months.
Okay.
It'll be September. September the 9th. No, I can't do that. 'Cause I'm on vacation. Oh, I'm sorry. I'm on vacation. September the 13th. Ms. Vargo, I want you to come back. September the 13th at 9 o'clock, okay?
Okay.
Mr. Quinn, you do not need to be with Ms. Vargo, but would you please remind her of that?
Yes, Judge.
All right, this matter is concluded unless there's anything further.
Nothing further.
Vincent Howard, please unmute.
Yes, Your Honor.
This is case number 221222. People of the state of Michigan versus Vincent Howard, scheduled pre-trial. Appearances for the record, please. Cornelius, the receipt of a sign, please.
All right, appearances. Who's the prosecution on Vincent Howard? Mr. Cheney is not on here. He's not here. That's not him. Nope. Who do we have County Jail?
Ready on Vincent Howard.
All right, we don't have the prosecutor on Benson Howard, Mr. Upshaw. As soon as the prosecutor's back, we'll go back to it.
Prosecutor lost power.
Thank you.
Wait on the hold on.
Prosecutor has lost power.
Mr. White Blake, I'm trying to get your prosecutor back.
You have to unmute him.
Thank you.
County, 'cause we can't hear you. Okay, who is that in Macomb County?
Michael Johnson.
Michael Johnson? Jeffrey Perlman is his attorney. Okay, Mr. Johnson, we don't see your attorney on yet, so we need your attorney here. As soon as your attorney arrives, we can handle your matter, okay?
Thank you.
We're gonna mute you back. Mr. Tenney, are you with us?
Apparently, sorry, I don't know what's going on today. Just another fun day. So,
All right, we're still on Benson Howard. State your name for the record, Mr. Tenney.
morning, Your Honor, Michael Tenney for the people.
Mr. Upshaw? Mr. Upshaw? Okay.
Yes, Your Honor.
State your name for the record. Mr. Upshaw, we need you to state your name for the record.
Yes, Your Honor, Randall Upshaw, P number 43574, on behalf of Mr. Vincent Howard.
All right, thank you. Mr. Vincent Howard, state your name for the record.
Vincent Howard.
All right, good morning to everybody. The court is in receipt of a settlement offer advice of rights form. Mr. Tenney, would you like to put the terms on the record?
Yes, Judge, if Mr. Howard, a plea is charged to count one, carrying concealed weapon, 5-year felony. There'd be a sentence agreement of 2 years probation. The people would consent to HIDA. If the court deems eligible, he must forfeit the weapon to the arresting agency, must not own, use, possess, etc., a firearm during the period of probation and any other terms and conditions set by the court.
All right, Mr. Upshaw, is that your understanding of the plea agreement?
Yes, it is.
Mr. Howard, is that your understanding of the plea agreement?
Yes, Your Honor.
Mr. Howard, raise your right hand. Do you swear or affirm the testimony you're about to give is the truth?
Yes.
All right, you can put your hand down, Mr. Howard. How old are you, Mr. Howard?
26.
How far did you go in school?
Some college.
Okay, good. So you graduated high school, is that correct?
Yes, ma'am.
So you read and write the English language, correct?
Yes.
You understand what's going on here today?
Yes.
All right, I have in front of me a settlement offer, advice of rights, notice of acceptance, in which the people have offered that you could plead to count one, carrying a concealed weapon, which is a 5-year offense. There's a sentence agreement of 2 years probation. The people consent to either if the deems eligible. You must forfeit that weapon to the arresting agency. You must not own, use, or possess, etc., a firearm during the period of probation, and any other terms and conditions set by this court. Is that your understanding of the plea agreement?
Yes.
All right, Mr. Howard, did you discuss this plea offer with your attorney, Mr. Upshaw?
Yes.
And are you satisfied with his representation?
Yes.
All right, down at the bottom of this form, I see Mr. Upshaw's signature, as well as your signature with permission. Did you give Mr. Upshaw to sign the form on your behalf?
Yes.
All right, in signing this form, you give up all those rights that are listed under the advice of rights and notice of acceptance. And did you go over those rights with your attorney, Mr. Upshaw?
Yes.
All right, knowing and understanding all the rights that are listed on that form under the advice of rights and notice of acceptance, you understand that you are indicating you wish to give up all those rights and plead guilty today. Is that correct?
Yes.
Other than this plea agreement, has anyone promised you anything else to get you to plead guilty?
No.
Has anyone threatened or forced you in any way to get you to plead guilty?
No.
Are you in fact pleading guilty voluntarily and of your own free will?
Yes.
Are you under the influence of drugs or alcohol at this time?
No.
And are you currently on probation or parole to this or any other court?
I'm on a delayed sentence.
You on a delayed sentence? Is that out of Third Circuit or a different court?
A different court.
So I don't know. It's possible that this could have a negative impact. Do you understand that?
Yes.
And you still willing to take the plea?
Yes.
All right, Mr. Tenney, ask some questions to establish factual basis.
All right, Mr. Howard, I want to take you back to November 2nd of 2021. We're in the area of 1841 East State Fair in the city of Detroit.
Yes.
And were you in possession of a pistol at that time?
Yes.
And was that in your, was the gun sticking in, or would you had it in one of your pockets?
Yes.
And would you agree that some or all of the weapon was hidden from plain view?
Yes.
And on that day, did you have a valid concealed pistol license?
No.
And people are satisfied, Judge.
Is the defense satisfied? You're muted, Mr. Upshaw.
Yes, Your Honor, defense is satisfied.
All right. Has the court complied with court rule 6.302?
Yes, Judge.
Yes.
All right, the court finds that the defendant's plea is understanding, voluntary, and accurate, and will accept the plea of guilty. Mr. Howard, you need to call probation when you hang up from here. Let them know you have taken a plea. You need to set up a pre-sentence investigation report. Their phone number, are you ready to take it?
Yes, ma'am.
It's 313.
Yeah. 313
224
224
2600.
2600.
Yes, call probation, let them know. Your sentencing date will be July 20th. July the 20th. Is that good for the parties?
Yes.
Yes.
Okay. All right, we'll see everybody back on July the 20th at 9:30.
Have a good day, everyone. Thank you.
Thank you.
Parties on Austin Hamrick, unmute.
Hello, Your Honor. How you doing today?
Hold on one second. I haven't called it. I'm doing well though. Thanks for asking.
This is case number 25883. People of the state of Michigan versus Austin Hamrick, scheduled pre-trial appearances for the record, please.
Good morning, Judge William Lawrence.
Good morning, Your Honor. Austin here speaking. Austin Hamrick.
Mr. Hamrick, you have to wait until I speak to you. We cannot have more than one person talking at a time. Okay.
Okay,
Mr.
I'm sorry.
Hamrick?
I'm sorry. I'm so
All right.
sorry.
People, please put your name back on the record.
Yes, sorry, Judge William Lawrence, P70481.
All right. Who's defense?
Good morning, Your Honor. Wright Blake appearing on behalf of Austin Hamrick, P37259.
All right. Good morning, Mr. Blake. All right, Mr. Hamrick, state your name for the record.
Good morning, Your Honor. Austin Allen Hamrick.
All right. Good morning, Mr. Hamrick. All righty. What are we doing on this case?
Judge, we have a resolution. We just have to execute all the necessary documents.
Okay. Do we have a plea form?
I have a plea form, Judge. It was my understanding that a signed plea form by the prosecutor was sent to Mr. Blake. I don't know if
Mr. Blake, was the signed plea form sent to you?
Not that I know of, but I could be mistaken. Who sent it? Ms. Cooper or you did?
It was sent by Leslie Cooper.
Well, it probably was, Judge. I have to send it back. I have to look at my file. Right now, I'm in circuit court in a live hearing.
Oh, okay. You want an adjournment, Mr. Blake?
Yes, please, Judge.
All right. You want to come back this week or you just want another day?
I can probably do Friday.
All right, we'll add you to Friday.
All right, thank you very much.
Judge,
Oh, hold on one second.
I'm
Yes.
sorry, Judge. Is there any way that can be done on, like Thursday? I'm standing in for Ms. Cooper today because Ms. Cooper has a medical situation that's going to keep her out the rest of the week.
Okay.
On Friday, I have a pre-defendant preliminary exam at 10 o'clock. That's my only issue.
Oh. Mr. Blake, can you do Thursday?
What date is Thursday, Your Honor?
That's the 16th.
I think that's kind of bad for me. That's why I suggested
All right,
Friday.
we're in Toronto anyway. We'll have to be at lunchtime. So we're gonna have to go out to July then. All right. July 5th.
That's good.
That's fine, Judge.
All right, July 5th at 10 o'clock.
Okay,
Yes,
have
Your
a good day, Your Honor. God bless you.
Same to you. We'll see everybody back on July 5th at 10 o'clock with the plea. Send
Okay.
over to the court.
Yes, Your Honor. Thank you.
Have a
You
good
can
day.
hang up, Mr. Hamrick. I'm still waiting on Mr. Crone. Is everybody here? Where's Rose? Okay. Party on Jerry Road. Can we call Mr. Crone? Okay. We got Macomb County on. Okay. This is case number 222450. People of the state of Michigan versus Jerry Rose, scheduled sentencing. Appearances for the record, please.
Good morning, Your Honor. Michael Tanian for the people.
And good morning, Your Honor. For the record, James Schlopp on behalf of Mr. Rose.
All right, good morning, Mr. Slop. Where's Mr. Rose? State your name for the record.
Jerry Rose III.
All right, good morning, Mr. Rose.
Good morning.
This is the date and time and place set for sentencing in this matter. Mr. Rose, do you consent to be sentenced over Zoom?
Yes, Your Honor.
All right, have the parties had an opportunity to review the pre-sentence investigation report?
Yes, Judge.
Your Honor, I have reviewed it with Mr. Rose. There's no corrections. It's factually accurate.
All right, Mr. Tenney, do you have any additions, corrections, or deletions?
None for the people.
All right, Mr. Rose, you had an opportunity to review this pre-sentence investigation report with your attorney,
Yes, Your Honor.
and everything in it is true and accurate?
Yes, Your Honor.
All right, Mr. Tenney, anything you'd like to say before the court imposes sentence?
Judge, this was a cop's evaluation, so we'll leave it to your discretion.
All right, what was my copy? I don't see anything written on
I
it.
think it was for Haida, Your Honor.
I have written down probation under HIDA, but the term to be determined at sentencing.
All right, let me change this PSI then to say cops agreement and HIDA probation. All right, Mr. Slop, anything you'd like to say before your before the court imposes sentence?
Nothing further, Your Honor.
Mr. Rose, anything you'd like to say before the court imposes sentence?
No, Your Honor.
All right, Mr. Rose. You want to get HIDA from this court. Court is going to give it, but there's going to be some requirements. You need to get your GED or high school diploma, Mr. Rose, okay?
Okay, Your Honor.
And you're gonna be given enough time on probation in order to get that. I'm going to change the probation. I'm not gonna make it 2 years. I'm gonna make it 18 months. And so on number 1, where it says you must participate, I'm gonna cross that out and say you must complete an adult education or GED program as directed by the field agent. They have on here 100 hours community service. That's absolutely ridiculous. I'm not gonna do that, but I'll get back to that. You must complete a mental health, domestic violence, or batterers intervention, or any other recommended treatment following an assessment by a qualified community-based service provider. You must not use any object as a weapon, and you must not own, use, or have under your control or area of control a weapon of any type or any imitation of a weapon. You must not be in the company of anyone you know who possesses these items. You must make genuine efforts to find and maintain legitimate employment of a minimum of 30 hours per week, unless you're engaged in an alternative program approved by the field agent. Mr. Rose, do you have a job?
Yes, I recently just got one.
And where do you work, Mr. Rose?
It's called Interstate Cleaning, and it's basically a third-party company that works for the Home Depot warehouse in Romulus, Michigan.
Okay, and are you full-time?
Yes, Your Honor.
Okay, how much you make an hour?
$17 an hour.
All right, very good. So you must provide ongoing verification of employment, and you shall not give reason to be terminated or voluntarily terminate your employment unless you first obtain written permission from the field agent. There is $68 in state costs, crime victims assessment in the amount of $130, and pursuant to MCL 791.225A as an apple as amended by Public Act 164 of 2019, you must pay a supervision fee of $30 per month for each month of regular supervision. Now, there are court costs in the amount of $1,300. So what I'm going to do is I am going to reduce your court cost down to just $300. You have the term of probation to pay it. You will have to do some community service, but not 100 hours. You can do 20 hours of community service in lieu of the rest of the court costs, okay? You can do that anywhere you want, Mr. Rose. If you attend a mass or church or whatever faith you may be, you can do it there. You can do Meals on Wheels, you can go to animal shelter, anything. You just need to provide documentation that you did 20 hours of community service, okay?
Yes, Your Honor.
Once you do that, $1,000 of your court costs will be vacated. And then I have $400 of attorney fees. Mr. Slop, you're appointed?
I am, Judge.
All right, so it's $400 of attorney fees. You have the term of probation to pay that. So, Mr. Rose, if you stay employed, you get your 20 hours of community service done and you complete your GED, which I believe you can do virtually now. You pay $300 in your court costs. I'm gonna reduce your attorney fees from $400 to $200. So I'll reduce those to half. So you pay your attorney fees, your court costs, get your community service done, and get your GED done. You petition the court to be off of probation in 9 months, halfway through, and I am going to allow this to be under hire. Okay, if you don't get it done within that time, you have 18 months to get everything done. Okay,
Yes, Your Honor.
all right, you need to call probation when you hang up, let them know you've been sentenced. Their number is, are you ready to take the number down?
Yes, Your Honor.
It's 313
Okay.
224
Okay.
2600.
Okay, I got it.
All right, this matter is completed unless there's anything else.
Nothing else, Judge.
Yep.
All right.
Nothing for the people.
Thank you.
You're welcome.
Thank you, Your Honor.
Thank you. You can hang up, Mr. Rose. All right, where's Mr. Pearlman? Are we sure that's what the attorney is on? Ask Hope about the files since she read them out and she asked. Mr. Tenney, do we know what's going on with Mr. They were, I don't see McComb on here anymore. Looks like McComb is gone. That was on Mr. Johnson.
I had it on my list for the 17th. So
The 17th of June.
yes, this Friday.
Oh, okay, well, maybe it's supposed to be on the 17th. Is it for sentencing?
So this is the one that he still has 3 cases in the district court. He's also trying to get him into drug court, which I don't think is going to happen. And we got to figure out a resolution on the other 2 that aren't a sentencing.
All right, because I'm only showing 2 cases up to date. One is a sentencing and one is a pretrial.
Right. He has 3 current cases with you. So that 19-9646. And then he's got 20-4996 and 20-5197.
Okay, that 5197 was not listed.
I failed to move them to the 17th, so they should be. I see the other one on the 17th. That's why it's only 2. I'm moving them now. That explains where the file is since it's drug court. Okay.
All right, well, they're trying to get him in drug court. He's not in there. Okay, so this will be on the 17th. Then we won't worry, but let's make sure that Hope has the writ for the 17th done. Because I don't know why they came on the day.
Because I got them on both days.
Oh, so she must have read them for the day too.
Parties on Rico Valentine. Not Valentine.
He is the boy.
Oh, Valentine. These are case numbers 22402, also 419. Both people of the state of Michigan versus Rico Valentine, both scheduled sentencing appearances for the record, please.
Good morning, Anna. Michael Tenney for the people.
Good morning, Your Honor. Joseph Dillard, P 37225 on behalf of Mr. Rico Valentine. Mr. Valentine, identify yourself for the record.
Rico Valentine.
Your Honor. Good morning. Your Honor, at this time, I have not received the pre-sentence investigation reports. It's been indicated that it was mailed to me. I've checked for it. I do not see it in my email.
All right, hold on a second. Ms. Shawn,
Yes, Judge.
can you email the PSI to Mr. Dillard, please?
Sure. Can you put your info in chat, Mr. Dillard?
Okay, it's 2 cases also.
Okay, thank you.
Mr. Dillard, I did respond to your email this morning with a copy of the PSI, and it's one PSI contains both cases. So that should be in your email, responding to the one that you sent.
Okay, and when did you send that one to me, Mike?
10/21 is the email stamped. So about 10 minutes ago.
Okay, oh, you just sent it 10 minutes ago. Okay, thank you. I'll check. And Madam Clerk, I sent a text to Mike Tenney, and it has my email in there. It's the 1022 text to APA Tenney from me.
You sent a text to Mr. Tenney, and what you want me to do about his text?
He's talking about the chat.
Right. She had requested my email, just saying I already have it there, but I'll send it over again.
Okay,
The clerk did not request your email. Ms. Sean requested your email. That's the probation agent.
Oh, okay.
But she doesn't need it if you have the PSI, Mr. Diller.
Okay, I'm gonna have to check my email.
Okay, can you do that?
Okay, okay, yeah.
And I guess you're gonna have to go in a breakout room with your client or either call him to go over the report.
Okay, let me confirm that I've received it. Give me a moment.
All right, well, he's doing that. Let's do something else.
Art Noden. Raheem Noden.
Hi, the people are ready. The defense attorney is Robert Kinney. I just actually saw him in Judge Cox in person, so I'm not sure if he's in the courtroom. I'm prepared to proceed, but if not, okay.
Okay, so you're not ready. Okay, thank you.
Ms. Hagar, what was she on?
She's on hold.
Oh, okay.
He checked in, she wasn't here. Now she checked in.
Attorney Francis Murphy, what is she on? She's on the call.
Are we ready on walls? Ms. Murphy? Attorney Francis Murphy?
All right, don't make she sat up, she's not ready.
Well, we waiting on Valentine? No, wait.
Mr. Diller, do you have the email?
Yes, Your Honor, I do have the report.
All right, do you want to go in the breakout room with your client?
Not yet, Your Honor. I would, yes, go ahead and put me in a breakout room with him. I'm going to be sending it to try to send it to his email where he can look at it.
All right, accept the invitation. Mr. Valentine, you need to accept the invitation. Diller, you need to accept the invitation as well. All right. Who's the prosecutor on McMillan? Because of the defense attorney too. Yeah. Is that Mr. Cheney's thing? Dr. McMillan? Mr. Cheney's gone. Yeah. Oh, no, here he is. Mr. Cheney,
Yes, Judge.
are you ready on McMillan?
Yes.
Okay.
The attorney who just here?
Yeah, it says Attorney Forrest Haddad is on Jacqueline McMillan.
Okay. Parties on Jacqueline McMillan, please. This is case number 215385. People of the state of Michigan versus Jack McMillan, scheduled pretrial. Appearances for the record, please.
And good morning, Your Honor. Michael Tanier for the people.
Good morning, Your Honor. Good morning to your staff. Ferris Haddad on behalf of Ms. McMillan.
Jacqueline McMillan.
All right, good morning, Ms. McMillan.
Good morning.
Haddad. All right, what are we doing on this today?
Judge, the last time we were here, there's a pending Cobb's evaluation request, and you had asked for medical records, and I'm double checking if I got them back. Which I'm looking in my emails now, and I do not have any.
medical records with respect to the victim?
Correct.
Okay, well, I can't do anything until I see that. Why don't you contact the victim and see if they can send them to you?
Sure. I mean, I can do that, Judge. I don't know if they have a full copy. And then the other issue is that if this were to go to trial, I need the certified anyway. So, but yes, I will reach out.
You do if it goes to trial before Cobb's. I don't need certified. So if the victim has them and you get them from the victim quicker than you can get them from the hospital, when did you send the subpoena out?
The original date was in April. I sent a follow-up the last time we were here back in May. It goes through an automated system for Sinai Grace. So typically they're pretty good about it, but you just have to wait for them to process it, unfortunately.
Well, we sent it out March and April. It's now June. Was there a
And
particular
October.
subpoena?
Yes, Judge, the subpoena was signed and it's been sent, and I get the emails that they received it. It's just, I don't know what's taking so long for them to actually produce them.
All right, so sounds like we need a court order.
That's fine. If I provide one, if I'm provided one, I can send one or I can write it up, whatever the court prefers.
Yeah, just draft one, Madam Clerk says she's not paid. You do draft one, I'll sign it. If they don't submit it by the date on the court order, then we'll have to show cause.
Yes, Judge.
We need to move this along. Okay.
Mr. Tinney, can I contact you and I'll still contact you in the meantime. Maybe we can continue plea negotiations at some point.
Sure.
Thanks.
Time late July or beginning of August. We should have everything by then. August 2nd.
Okay, can it be later in the morning again, Judge? I have at 8:30.
Yes, August 2nd at 11 o'clock.
Thank you.
What I'm gonna tell you, Mike Tinney, is just get the order down to me. I'll sign it. And if we don't have those records by August 2nd, make sure that you put on that order, they need to be submitted like the end of July. That way
Yes,
we'll
Judge.
know by August 2nd if we have them or not. And if we don't, I have to show cause.
Will do, Judge.
All right, we'll see everybody back on August 2nd at 11.
Thank you, Your Honor.
Thank you. This matter is concluded.
Ms. Murphy,
Yes, Judge.
this is the clerk. Where's your client?
He's on Zoom.
Okay, you ready?
Yes.
What's the client's name?
Are you on Walmart, please unmute?
Yes, good morning.
All right.
These are case numbers 221548 and also 218379. Both people of the state of Michigan versus Reno Walls, both scheduled pretrial appearances for the record, please.
Good morning, Your Honor. Michael Tinney for the people.
Good morning, Judge Francis Murphy for Mr. Walls. Mr. Walls, will you please state your name for the record, sir?
Mr. Reno Walls.
All right. Good morning, Ms. Murphy and Mr. Wall. All
Good
right.
morning.
The last thing I have on here, there was a plea that was made, and I have no more offers after May 5th, and clearly we're after May 5th, so I'm not exactly sure what's going on, Mr. Tinney.
Judge, I did file my witness list and jury instructions, I believe yesterday. In speaking with Ms. Murphy to go over the jury trial readiness form, she still had a couple things that she needed to go over, so I'll let her take over at this point.
Well, I did send over medical records to Mr. Tinney with respect to the RNO case. There may be two witnesses that we call that are the treating physicians of Mr. Walls, so I'll file a witness list on the R and O case. We'll have no witnesses on the drug case. I talked to Mike yesterday. I guess Mr. Cobb has been out. So I did file or email and call Terry Anderson to see if there might be a chance for resolution. I think a better offer is appropriate for Mr. Walls. He's had no felony charges since the 90s. And I think there's some issues with the facts in both cases. So, but we're ready to set it for trial if that's the next step.
All right, well, I need the jury trial readiness form, which I don't have.
I have them prep, Judge. I can send them to Ms. Dove now.
All right.
Consent should be there in just a minute.
Alrighty. Okay. I have both the jury trial readiness forms, but I don't have any of the supporting documentation. That being the information, not the information, but
All right. That's coming to her too.
all right, well, while it's coming, we can go over it. As to case number 21-1548. I'm sorry, 21-8379, which is the oldest case number. I'm showing the people have 3 to 5 witnesses. Defense, you do not have any witnesses on that case. Is that correct?
Yeah, if that's the drug case, that's correct.
That's the R&O case.
Okay,
right.
but yeah, in the R and O case, we have 2 potential witnesses.
I'm sorry, I didn't hear you, Miss Murphy.
We have 2 potential witnesses on the R and O case.
All right, then I need did you file the witness list?
I'll do that today.
Yes, because this can't go in until we receive the witness list. Number of days to try the case, 1 to 2. No
Yes.
witnesses are traveling from out of state. We don't need any interpreters. All attempts at resolution have been exhausted, including the cops, is checked. Option of a waiver trial was discussed and rejected by one or both parties. All motions, including motions in limine, have been heard by the assigned judge. There are no labs, there are no experts, so there are no dollar issues. There are no competency issues, Ms. Murphy? Is that
No,
correct?
Judge. That's correct.
Okay, so that should be checked. Board is checking that. Witness list by both parties. Well, I now have the people's witness list as well as the jury instructions. So I need defense's witness list still outstanding. Have that witness list in today, Ms. Murphy.
Yes, Judge.
And then the felony information I have. All right, these jury instructions are to the possession case. We don't have the jury instructions for the R&O.
I thought I sent both.
Hold on 1 second. All right, they're just crossed. All right, so I have it. Let me put them in order. This is the R&O. Jury instruction. Madam Clerk, you have a paper clip. Okay, and then for the Peewit case, thank you. For the Peewit case, defense, you do not have any witnesses, is that correct?
Correct.
And I'm showing that people have 5 to 6, 2 to 3 days to try. No interpreters needing, no one comes from out of state. All attempts at resolution have been exhausted, including the cops. All motions have been heard, no lapse, no experts, no Daubert issues, no competency issues. I have the witness list, so I will check that. And I have the felony information. So the only thing that I need is the defense's witness list on case number 218379. And then that one can go in as well.
Okay, I'm getting that ready now.
Okay. All right, so we will give you a review date, September 22nd.
Judge, did you say September?
Yes,
Okay.
that's a review date, not a trial date, that's a review date. Your client is out. So most trials that are being done right now are for people who are in. So
Understood. Judge, I'm out that day. Is there, I could do the Thursday
we'll give you
before.
another day.
Okay.
September what? September 23rd.
Okay. 9 a.m.
Yes. Did you email the witness list?
I can email it or e-file it.
Well, you need to e-file it for Odyssey sister, for Odyssey, but why don't you email it to Ms. Dove so we can get it faster and we can get these sent down to court administration, okay?
Okay.
All right, anything further?
Nothing for the people.
Would you just mind putting your email in the chat, Madam Clerk?
It's in the chat. It's in there already. mia.dove@3rdcc.org.
Okay. I do not see it. I don't know if I logged in after it was put in there. If I have any issues, I'll get it from you, Mike, okay?
Yep.
Okay. All right, thanks, Judge. You're all set, Mr. Walls.
All right. Thank you both. Have a great day.
Officer Raheem Nolan, please.
All right. We concluded on that. All right, man, concluded. Good morning, Mr. Kenny.
Good morning, Judge. Apologize for being in the courtroom.
Okay. All right, so what do we have now?
Raheem Nolan.
All right, let me get off this. That's what it's on. Yeah.
This is case number 211019. People of the state of Michigan versus Raheem Nolan. Scheduled pretrial. Appearances for the record, please.
Good morning, Rhonda Hadar for the people, P84161.
Good morning, Judge. Robert Kenny, appearing on behalf of Mr. Nolan, 35842.
All right, good morning, Mr. Kenny. Mr. Nolan, state your name for the record.
Good morning, Your Honor. Raheem Nolan.
Okay, good morning, Mr. Nolan. So it looks like we're going over the jury trial readiness form. Is that correct?
Yes, Judge.
Yep.
All righty, I am showing that the people have 17 witnesses. Is that correct?
Yeah, Judge, I closer to trial, I'll unendorse duplicates. I just don't know who's still going to be with the police department and which, like, we won't need like both evidence texts. I just have to figure out who will still be around.
Okay, so the court and the people, I'm sorry, defense has one witness. Is that correct?
Yeah, I don't know if I put on there, outrage just eyewitnesses known to the prosecution, but I believe she's got them all listed anyway.
Okay. 5 to 7 days to try the case. No one is traveling from out of state, is that correct?
None for the people.
None for the defense.
Okay. And no interpreters needed?
None.
All right, all attempts at resolution have been exhausted. None of the bottom is checked, so we're gonna have to go over this. All attempts have been exhausted. Option of a waiver trial was discussed and rejected by one or both parties, correct?
Correct.
All motions, including motions in limine, have been heard by the assigned judge, yeah?
Yes.
Are there any labs in this case?
No, don't believe so, no.
No? Okay. Any experts?
There's some medicals and there's some.
Medicals, but not labs. Okay.
No experts, no.
Okay. There are no issues with competency, Mr. King?
No.
Witness list. All right, I have the people's witness list and I have defense. Okay, I have both and I have the information. All righty, we are good to go. So, Mr. Nolden, because you are out, your case will not come up anytime soon. So I'm going to give you a review date. Mr. Nolden, you do not have to appear for the review date as long as you stay in contact with your attorney. Can you hear me, Mr. Nolden?
Yes, ma'am.
All right, let me have you come in the camera because we are in court, okay?
I'm sorry.
All right, so as long as you stay in contact with Mr. Kenny, you do not have to come to court. If he loses contact with you, however, you will have to indicate that to the court and then we'll issue a warrant, but hopefully that won't be the case. So your review date will be September.
Oh, 22nd.
All right, September 22nd at 9 o'clock. All right, is there anything further from the parties?
Did you say 22nd, ma'am? 22nd or 27th?
22nd, but you do not have to be here, but it's September 22nd,
Okay.
okay?
Yes, ma'am.
Thank you, Judge.
Thank you. Matters concluded. Right here, madam. Let me have another paperclip. Okay, well, I gotta read it. All right, this is for home. Have a good day, Mr. Kenny.
You too, Judge, thank you. Can I speak to this meeting?
No, what you need?
The case in front of Judge Lincoln.
I'm so happy. My day is made.
Is that
I
today?
just got the email. I'm ecstatic.
Let me see. Is this the email you just handed me?
No, not here. That's an email that I'm good.
Good morning.
Mr. Gooden, please unmute. This is case number 202899. People of the state of Michigan versus Glenn Gooden. This is a scheduled review date on the update of Mr. Gooden's probation status. Appearances for the record. Will Mr. Gooden state your name, please?
My name is Glenn Aubrey Gooden II.
All right, good morning, Mr. Gooden. How are you?
I'm well. How you doing, Judge Baker, today?
I'm doing well. Are you still in team wellness?
Yes, Your Honor. I'm still at Team Wellness. I've been here, since you sent me here, and I've done all. I got my relapse prevention plan in order. I've been going to my therapy sessions every day, and I also have an individual therapist that I've been seeing, Your Honor.
Very good. So it's working for you. Is that correct?
Yes, Your Honor. I had wanted to ask you a question. Well, you know, Your Honor, when I talked to you when we last had our last meet, you told me when we come back in a month, you was going to talk about, because I was here in November, December, January. I left in January when my wife got ill. And then this time I've been here April, May, and this is June. And I was just going to ask you, Your Honor, I've been doing everything over here. I done finished the groups that I was supposed to attend over here. I finished the package. I'm done with that. I'm done with everything it is to do over here. I was just going to ask you, could you please find it in your heart to discharge me today, Judge Baker?
I think I remember that. I asked you to have your, whoever your.
I know it, but I would have to have you hold on for a second, because the lady, she upstairs they got some type of people came in here from OSHA or something like that, or some type of bot, and she up there in the meeting. The director, her name is Judge Baker, but I can go try to grab Miss Danielle right quick so she could update you on those dates, maybe.
All right, well, yeah, that's the issue. I indicated what the time was so that somebody could be here with you. So
can I, is it possible, can I run and go get somebody right quick, Judge Baker? It'll only take a second.
Well, I have another hearing in 2 minutes, but go ahead. You can go ahead and try.
Go ahead and try. Okay, all right. I'll be right back, Judge Baker.
Who is Mr. Debo? Attorney Debo has been sitting on this phone. Oh, it's a sentencing on Harris Johnson. Mr. Johnson's on there. Yeah, let's do that one.
Parties on Harris Johnson, please.
Good morning, Your Honor. Ronald Devo here on behalf of Harris Johnson.
All right, we haven't called it yet.
Okay.
April, May, and June. Judge Baker?
Yeah.
Yeah, I'm back. I've got my therapist here, Mr. Smith. He
Okay,
knows.
hold on a second. Hold on a second. I'm doing another matter.
Okay.
Okay. This is case number 218959. People of the state of Michigan versus Harris Johnson, scheduled sentencing. Appearances for the record, please.
Good morning, Your Honor. Michael Tanner for the people.
Good morning, Ronald Devo, P63897, on the behalf of Harris Johnson, who is here via Zoom. Please state your name for the record, Ms. Johnson.
Good morning, Your Honor. Iris Johnson.
All right, good morning. All right, this is the date, time, and place set for sentencing. Ms. Johnson, do you consent to be sentenced over Zoom?
Yes.
All right, have the parties had an opportunity to review the pre-sentence investigation report?
Yes, Judge.
Yes,
All right, starting with the people, are any additions, corrections, or deletions?
Judge, I have one to the face sheet, and that's gonna be on the plea agreement section. Just want to note on there that part of the plea agreement is that we are dismissing counts 1 and 2.
correct.
Counts 1 and 2. All right, anything else?
That's it for the people, Judge.
All right,
Oh, I see what you're saying.
Mr. Debo, anything on behalf of defense?
No, Your Honor.
Okay, well, are you appointed, Mr. Debo?
Yes, ma'am, I am.
Okay, all right, Ms. Harris Johnson, did you have an opportunity to review the pre-sentence investigation report with your attorney?
Yes, Your Honor.
All right, is everything in the report true and accurate?
Yes.
Yes,
Okay, Mr. Tenney, anything you'd like to say before the court imposes sentence?
For plea agreement, we'll move to dismiss counts 1 and 2,
Court will dismiss counts 1 and 2.
then ask that you file a sentence agreement.
All right, defense, anything you'd like to say before the court imposes sentence?
no, Your Honor.
All right, Ms. Johnson, anything you'd like to say before the court imposes sentence?
Your Honor, I wanted to ask if I could get the court fees waived.
Are you currently working, Ms. Johnson?
Yes, I'm working. I go by clientele, and my clientele has been very low since COVID.
Okay, what do you do for a living?
I'm a licensed massage therapist.
Okay, do you have transportation, Ms. Johnson?
Yes, I do.
Okay, all right, Ms. Johnson, the court will sentence you pursuant to the plea agreement of 1 year probation. You must forfeit the weapon to the arresting agency, and you must not own, use, possess a firearm during the period of probation. You must not use any object as a weapon. Oh, I just did that. You must make genuine efforts to find and maintain legitimate employment. You indicated that you're in business for yourself. So you just need to provide documentation somehow showing probation, how it is that you are in business for yourself. There's $53 in state costs. Those cannot be waived. Your crime victims assessment is the amount of $75. There are court costs. So what I will do is I will waive your court costs. Right now they have $400 in court costs. I'll waive those court costs, but you'll have to do, they have on here 40 hours of community service. I'm going to indicate 20 hours. You have to do 20 hours of community service in lieu of your court costs. Okay?
Okay, thank you so much, Your Honor. I really
All right,
appreciate it.
All right, if you have a church home, you can do it at your church. You can do it at the animal shelter with Meals on Wheels, wherever you want. You just need to get the documentation submitted to probation. And then there's $400 in attorney fees. I will reduce those down to $200. You have the time of probation in order to pay it, which is 1 year. If you get your $200 attorney fees, your 20 hours of community service done, and pay these other little 53 and 75, you can petition the court to be off probation in 6 months. Okay?
Okay, do I go through my probation officer to do that, Your Honor?
To petition the court, yes.
Okay. Thank you so much, Your Honor.
It's my duty to advise you that you have a right to request leave to appeal from the Court of Appeals to appeal your plea and sentence. If you cannot afford an attorney to prepare your motions, the court will appoint one for you at public expense. And if you wish to do that, you have to request an appointed attorney within 42 days of today's date. We will send you the appellate rights form, although you got a misdemeanor, so I'm assuming you're not trying to appeal it. But we will send you the appellate rights form to your attorney. Does your attorney have permission to sign that form on your behalf, indicating you received the form?
Yes, he does, Your Honor.
All right, that's the form you must file with the clerk of this court within 42 days of today's date. That's only if you wish to appeal your plea and sentence. If you do not wish to appeal, you don't need to turn the form in. When you hang up today, you just need to call probation, and that number is 313-224-0000. $2,600. And let them know you've been sentenced today, okay?
Okay.
All right.
Thank you so much, Your Honor. You have a wonderful, blessed day.
You too. Matters concluded.
Thank you,
All right,
Your Honor.
let's go back to Mr. Gooden. Gooden. Let me call up this. What's his first name? Gooden.
Judge Baker. Didn't you hear what she said? I'm about to go back.
Calling case. This is case number 202899. People of the state of Michigan versus Glenn Gooden. This is a review date in progress. Mr. Gooden, state your name again for the record.
My name is Glenn Aubrey Gooden II, Judge Baker.
All right. Now, I had indicated for the record, Mr. Gooden wants to be discharged from the Teen Wellness Program. And I told him that I need to speak with someone at that program who can give me an update on Mr. Gooden and let me know whether Mr. Gooden is ready to be discharged from that program. Do we have somebody here on the phone?
Yes, we have somebody here on the phone. Gotta slide up.
Sir, can you state the name for the record?
Yes, my name is Coy Smith.
All right, Mr. Smith, and what is your position there at Teen Wellness?
Clinical therapist.
All right, and do you see Mr. Gooden?
Yes, I do.
All right, Mr. Gooden is asking to be discharged from the program, and so I want to basically get a follow-up from you as to whether you think Mr. Gooden is ready to be discharged.
Yes, he is.
Okay.
He
All right,
doesn't.
then. Go ahead.
No, he doesn't have he doesn't have any infractions. Since he's been here, he's been one of our most engaging members. He follows all the rules. He does what he's told. And we haven't had any problems with Mr. Gooden. I wish I could say that for the rest of them, but Mr. Gooden, he's been exemplary.
All right, Mr. Gooden, I will discharge you from the program. I believe you are still on probation. Ms. Jones, when is Mr. Gooden's date for probation? Last day, when is his probation end?
And Judge Baker.
One
I'm
second.
sorry. I'm sorry, Judge. Hold on.
5/17/2025. Yeah. All right, Mr. Gooden, you can be discharged from the program, but I do want you to continue to do outpatient with Teen Wellness to go in and go to the meetings, okay?
Okay, Judge Baker, can I get my tether off now? Because it's been 6 months, same amount of time. Can I get my tether off now too, please? Because it's been the same amount of time. You know, I've been on tether. You ordered me and I got the 6 months in on tether. Can I get that off too, please?
Sure, court will remove the tether.
Okay, thank you, Judge Baker. So I can leave today? I'm discharged?
Yeah, we're doing the order now.
Okay.
Mr. Gooden, you need to, do you have employment? Where are you going when you leave there?
Yeah.
I'm going to 1919 3 Prevost. That's the house I stayed in with me and my wife on. Remember I told you my wife passed in January. That's why I left here in January. I stayed at 1919 3 Prevost, Detroit, Michigan, 48235.
All right, Ms. Sean, are you with us?
Who you talking about, Kim and Sean?
No, I'm here. I'm here. Can I have that address again, please?
1919 3 Prevost. You still need me?
Is there a phone number?
Do I have a phone number? Yeah, area code 248-252-7003.
Thank you, sir.
All right, do you have employment, Mr. Gooden?
I'm disabled, Judge Baker.
Okay, so you get disability?
Yeah, I'll be getting, I see what happened was I was on it and then I got kicked off because I kept going back and forth to jail. So I got to I already got my application, reapplying again right now, Judge Baker.
Okay, All right,
Okay.
I hope, Mr. Gooden, that I do not see you back here, okay?
Okay, thank you very much, Judge Baker. You have a good day.
You're welcome.
Okay.
Yeah, send it to you. Or send it to Ms.
Mr.
Shawn.
Gooden,
Yes,
does Team Wellness need anything from the court?
just for the people to come take the tether off.
You have to go
No,
to them.
you have to go to them to get that taken off. We want to
Oh, I
know,
do?
do they need the order in order to discharge you?
Yeah, the order in order to discharge me. Well, he heard it already. Mr. Smith heard. Yeah, you can send the order over here. Can you fax it over here or something?
We're gonna send the order to the probation, Ms. Shawn, and Ms. Shawn can get it over there.
Okay, all right. Thank you very much, Judge Baker.
All right, have a good
All right.
day.
Uh-huh.
Yeah, I'm about to take a break. Ms. Shawn, we're sending you the order.
That works, okay.
Where's Mr. King? And Miss Eva, pronounce your last name for me?
Good morning, it's Tkaczyk.
Miss Kate, where's your client?
My client should be in person in the court, so he must be in the hall.
He's not.
I talked to him this morning. I'm going to call him, Judge. Please give me a few minutes.
Is Sheriff Brand? Where my sheriff?
Mr. Lorenzo Williams is checking in downstairs in the court.
Thank you. He is on his way up. Thank you.
Lori Schoen, I'm with the probation department, and I just got off the docket with a Glenn Gooden, and he was with someone from Team Jefferson, and I'm supposed to email something to this person, but I didn't get any contact. I mean, nobody told me who to send it to. Sure, let me pull it up. Sure, okay. Glenn Aubrey Gooden, 5/23/68. And he was just on Zoom in my courtroom, and he gets to be released, and they sent it to me and said, send it to them. I'm like, send it to who? I don't know who to send it. I'm sorry, I'm 5/23/68. And his name is Glenn with 2 N's, and Gooden, Gooden.
Ms. Sean, you're not muted, by the way.
Possibly. Thank you.
Mr. Dillon.
Yes, Your Honor.
Mr. Clerk. But while we're doing this case, can you try to find Mr. Dugan that's holding up our document?
Can I do what?
Find your client, Mr. Dugan.
He hasn't checked in yet.
Nope, and we're gonna do a case, so when we get through with that, we can do you and call his case. That's why I'm asking you to find him.
Okay,
Hold on.
all right, I was still reading the reports, but okay, I'll try to put a word out for him.
Oh, we're gonna adjourn it.
Huh?
But you read the report on who?
Valentine.
Oh, no, we adjourning that. Hold on. Let me call him.
Don't adjourn it just yet.
No, the judge said we're adjourning.
I got but the thing is, I have another case here. I still have another case. So if I can knock out all my cases at one time, that would be good. We're just about ready.
So you trying to go back in the breakout room?
You can send me there, or I can just sit here and read it myself. And then if I got to go in with my client, I'll go back in again.
You just go ahead and read it. Mute yourself. We gonna handle what we handle and be ready when we get through. Thank you. Go ahead and mute. Okay.
Who is Teresa A13?
Teresa's A13. Can you unmute, please? Or be removed.
What's the victim's name in this case, Mr. King?
Her name is Sydney Taylor. She's in that room right there waiting. I'm just gonna wait for Mr. Williams to come up front before she comes in.
Okay.
Miss Teresa's A13, you are now being removed from the courtroom.
All my cases at one time.
Hello?
That would be good. We're just about ready.
Teresa's A13, please identify yourself.
All right, you just sit.
Just remove Judge. Explain.
Teresa Flores, hello.
Why are you here, ma'am?
I'm on a case for Kevin Gladney.
That case has been heard already, and you should be viewing via YouTube.
I've been on YouTube, I haven't seen it.
Well, we've done it already, Miss Teresa, so you can hang up. That's already been handled.
Okay, so when's the next court date?
Say it's concerning your daughter. July 5th, and you have to view via YouTube. You have to disconnect now, July 5th. Thank you.
July 5th. Okay, thank you.
You're welcome.
Bye.
All right, so parties on Roy Lorenzo Williams Bay, please. This is case number 211710. People of the state of Michigan versus Roy Lorenzo Williams Bay. This is a bench trial in progress. Appearances for the record, please.
Good morning, APA Larry King for the people, P78774. My completing witness, Miss Sydney Taylor, is in the witness waiting room. I just asked if not available. Could you wait for it or should I wait?
You can have it.
Oh,
Brad
okay.
is over there. Sheriff Brad can get her. She can sit in the back.
Yeah, she is. Thank you, Your Honor.
You're welcome.
Good morning,
All right,
Eva.
she's not in here.
Oh, there she is.
All right, defense, please state your name for the record.
Good morning, Your Honor. Eva Tkaczyk, P70002. I'm representing Mr. Lorenzo Williams, and my client is present in the courtroom.
All right, state your name for the record, please.
Lorenzo Williams.
All right, good morning, Mr. Williams. You can have a seat. All right, this is a bench trial, and we are here today for the court to render its verdict with respect to the evidence. And let me just make sure I do have, now, defense or the people submitted an amended information. Can you print that out? Which had some dates on it. However, the charge is for aggravated stalking with respect to element one. First, that the defendant committed two or more willful, separate, non-continuous acts of unconsented contact with Sydney Taylor. Second, that the contact would cause a reasonable individual to suffer emotional distress. Third, that the contact did cause Sydney Taylor to suffer emotional distress. Fourth, that contact would cause a reasonable individual to feel either terrorized, frightened, intimidate, threatened, or harassed. And fifth, that the contact caused Sydney Taylor to be terrorized, frightened, intimidated, threatened, or harassed. And sixth, that the stalking was committed in violation of a restraining order of which the defendant had actual notice. That is the charge of aggravated stalking. That's the jury instruction. So this court is only, these dates got amended. Defense was going back and forth about whether there were additional dates between a particular time period. I don't believe this was the time period that was on the original information. So the court is simply going to go by the jury instruction, which means at the time that this PPO was in effect, were there some incidents that took place, okay? By the charge, all right? And we're not gonna worry about, because I think you're gonna have an issue with defense objecting to you amending this and then changing the dates on here. So the court is simply gonna go by what the charge is, and we're gonna follow the law that way. All right, the court heard testimony from Ms. Sydney Taylor, who indicated that she knows the defendant, Mr. Williams Bay, has known him. I believe at the time of this incident, the child was 5 years old. The child is 9 now, or at the time they testified. They have a child in common, so clearly she's aware of who he is. Ms. Sydney Taylor also testified that on the date in question, which was December the 12th, 2008, she originally testified that she stopped at a Dunkin' Donut. She said she believed the time was between 8:15 and 8:30 a.m., but she knows it's after she dropped off her daughter at school. And that location was 14900 East 8 Mile Road in the city of Detroit. She indicated that that is her normal practice to always go to this Dunkin' Donuts, and that because she had been with Mr. Williams Bay. I'm not exactly sure from the testimony, because both of them were quite hostile, both the defendant and the victim, with respect to their relationship, whether they were actually in a dating relationship or was it simply casual where a child was produced. Either way, he was aware of her whereabouts and that she always went to this Dunkin' Donuts on a regular basis. And it was her testimony that on that date of December the 28th, 2018, this is on page 15 of the transcript of the testimony, which was taken on November the 17th, 2021. Starting on page 14, Ms. Sydney Taylor testified that she received a call, and the call was blocked. The person had blocked the number out, but she was familiar with the voice because clearly she knows Mr. Williams Bay. They have a child in common. They've had a relationship, whatever they call it, whether it was monogamous or not, they still had a relationship. When she answered the phone call, she heard a person on the phone who she determined to be Mr. Williams Bay immediately. And she indicated it was father of her child. And just that he breathed into the phone and he said that you can run, but you can't hide. And I'm always going to be able to find you. And she talked about how that made her feel. And then she indicated that she was at a Dunkin' Donuts, which she knew to be a green light location. And the reason that is important is because she knows that green light locations have video. And so she wanted the defendant to come into the Dunkin' Donuts. I think she tried to force him into the Dunkin' Donuts. And she said that his statements to her was, "Nah, bitch, I know I could have got you, but this is a green light location." And that's when he said, that's when you told him to come inside. And her answer was yes. She then indicates that she gets that call. She looks outside. The Dunkin' Donuts is all glass. She could see a black Mercedes Benz, which she believed to be the defendant's. That's the type of vehicle he was driving at the time that she was dealing with him. She indicates that she gives her child, who I believe is a second child, a son, a younger child, over to the individuals that worked in the Dunkin' Donuts. She went to the door, and when she went to the door, she could then see in the vehicle, and she saw that it was Mr. Williams Bay, and she testified that she was approximately, I'm not sure if it was 25 to 30 feet or 25 to 30 yards. But she saw him, and then he sped off, and she contacted 911. She also testified that she had Mr. Williams Bay served with PPO back on July the 2nd of 2028. The court was then given People's Exhibit, which is actually a certification of records of a personal protection order. It is ex parte, and it is dated July 2nd, 2018. And it is with respect to Mr. Williams Bay not basically being anywhere near or contacting the victim in this matter. And there were different allegations put in the personal protection order. On the last page, there's a proof of service. And the sheriff's name is Daryl Webb. My understanding is I believe he works for, is the Oakland County Sheriff's?
Yes, sir.
All right. At the top, it says, he's checked the officer's certificate. I certify that I'm a sheriff, deputy sheriff, bailiff, appointed court officer, or attorney for the party under MCR 2.104A2, and that I served a copy of the personal protection order by personal service. And the name of the respondent, Roy Williams, and the completed date of the service, complete address and date, July 2nd, 2018, 40 North Main Street, Mount Clemens, Michigan, 48043. Is that the address of the Mount Clemens Court?
I don't know offhand, Your Honor. I
Okay.
apologize.
Well, anyway, I believe it is, but anyway, that's the location. So, the sheriff has indicated he served Mr. Williams Bay, who testified and claimed that he was not served. However, he did admit that there had been PPOs by Ms. Taylor against him. He claimed that he also filed one against her, but we never got any evidence of that outside of his testimony, nothing to corroborate it. And although he claims that he was not served with that order, there is nothing in the evidence that tells me that it was not served, because it's a certified copy. There is a sheriff's signature on it that says he did serve Mr. Williams Bay. So that being the case, the court is going to proceed based on the evidence that has been admitted on the record right now, and that there was testimony from Ms. Taylor that she had him served, and the court has exhibit number 1, which is a certified document indicating that Mr. Williams Bay was served. So that being the case, I'm going to find that he was served. So now the time in which the PPO was in effect was to December of 2018. So the question becomes, were there some contacts made during the time of this PPO? So we have a couple of things that are going on. We've got some text messages that were also provided to the court, and the court actually had to go through all the testimony again in order to determine, based on what was submitted to the court, whether these text messages were done during the time of the PPO. People's exhibit number 4, the victim testified, was done June of 2017. That being the case, it would have been before the PPO was in place. So I cannot take that into consideration. Also, as People's Exhibit 5, the victim testified was August of 2017. That being the case, I cannot take that into consideration. People's Exhibit 7, however, the victim testified was a text message she got on October 2018. It comes from the number of 313-739-3140. It has bum at the top of it. I believe the victim testified that is the name that she had in her phone for the number that is belonged to the defendant in this case. The defendant himself testified that that was his number at the time, 313-739-3140. And in the text message of People's Exhibit 7, he's got, "Bitch, I was trying to be nice to your ass by taking you to lunch to discuss our course of action for our kids." Shaking my head, "Never again." And she texts back, "Leave us alone." He says, "Be on time with my daughter. Now carry on." Calls her a stalker, "Good night." She also testifies that People's Exhibit 8 was during September 2018. And I guess this is also, they were having some issues with respect to custody. Again, it's the same number at the top, 313-739-3140. Your concern is with Harley. Your concern with Harley is you hung up on me when I called you to discuss our daughter. You feel a need to always to conference some woman into our business. Your daddy don't run shit over here, nor does his old ass want to see me. I'll deal with it myself. You don't have the heart into what matters the most. And then her response, I think, is the third party is needed, something else. Then there's another one, 313-739-3140. Again, same number, People's Exhibit 9, testified to September 2018. And she goes on, "There is a, every time I feel like you some money, you manage to fuck it up. My bills are paid, zero balance, so I can collect my unemployment and disability and never leave the house. You, on the other hand, have to be so difficult. Continue to take care of Alex while my daughter inwardly hates you." Oh yeah, you didn't. All right, so it's a bunch of negative information. And then there's also People's Exhibit 10, which she testified to was June or July of 2018. That was not quite as clear. The PPO was actually July 2nd, so it could have been in June, so I'm not going to take that into consideration. Mr. Williams Bay testified himself that this was his phone number, and he had this phone at this time. However, he also testified that he did not he did not text the victim at this time, and he claims that her number was blocked. I went back to review the testimony that Mr. Williams Bay gave. And Mr. Williams Bay did indicate that he had verbally in March, when he testified on March 31st, 2022, on page 10 of the transcript, when asked, okay, do you recall her even, you are not even a smart, dumb bitch, more likely a pathetic, broke, miserable, freeloader bitch. Do you recall sending her that message? I recall telling her that in person. I don't remember what year, but I said that verbally to her. So you have said those words to her previously. I said a lot of things to her. So he admits to being verbally abusive. I don't find it a stretch that if he's verbally abusive, that he wouldn't text it, which he admits himself. Also, there's no explanation as to who would be using there was no testimony by Mr. Williams Bay that somebody else had the use of his phone. He testified that this was his phone. So I'm not sure who would be texting the victim regarding their child outside of Mr. Williams Bay. I mean, I don't understand what anybody else would get out of that. I'm not even sure how anybody else would know anything about what's going on with their children. So it would be incredible for this court to believe that some mystery person got Mr. Williams Bay phone and decided to text the victim about their child. I don't believe that. I believe that these texts came from Mr. Williams Bay. That came from his phone. He doesn't say anybody else had control of his phone. There was no evidence of that outside of the fact that he had his phone. In addition, we then have the incident that took place on December 2nd, I believe it is, on 2008, in which Mr. Williams Bay testified that at that time, he was no longer driving. And let me say for the record that the court did view video of this Mercedes-Benz coming into Dunkin' Donuts, which was, I believe, People's Exhibit 11. No one gets out to come in to order a Dunkin' Donuts. The car just comes in and parks and then speeds off. At the same time, I see the victim who turns around and looks outside, takes her child, puts it in the back with a worker. Not sure why you give a child to a worker at a restaurant unless you were concerned about something. She indicates that's the time she got the phone call, turns around and sees the car. But Mr. Williams Bay says, well, I didn't have that car in 2018. All right, well, when the court heard that information, at that point, I wrote that down because if Mr. Williams Bay didn't have the car, then I got some questions about whether that's Mr. Williams Bay in that Mercedes-Benz. But I'll go back to look at the testimony, which I believe I remembered. And Mr. Williams Bay testified with respect to the Mercedes on page 97 of the testimony in November. When asked about the vehicle, all right, Mr. Williams Bay testified on page 97, started at line 11. I owned it up until February 2018 when I purchased a new vehicle. So what vehicle were you driving in 2018? I was driving a silver Ford Focus, not Focus, excuse me, Ford Fusion. I see. His own lawyer, I believe, asked this question. Do you know who was driving your black Mercedes-Benz in December of 2018? His own lawyer asked this question. Not sure that was the best question to ask. If your client indicated he got rid of the car in February 2018, I'm not sure why he would even know who had the car in December 2018, but it was asked and he answered. No one was driving it. Well, how could he know that if he doesn't have a car anymore? Well, that's because, okay, was the vehicle sold to somebody? She never asked a question if you don't know the answer to it. It was given to my son. Was it your son driving this vehicle? No, he wasn't driving it. He wasn't of age to legally drive. I kept it. I did not trade it in because he wanted it. Well, and that means Mr. Williams Bay still had access to this vehicle. So he wants the court to believe that he was driving a Ford Fusion and he gave his Mercedes to his son, who's not even legally able to drive at this particular time. Thus, and his son is living with him. So he has access to this vehicle. Okay, so I had given it to him, but it was parked. Actually, too, as I recall, the registration had expired on my birthday. And again, I had a new plate for the vehicle that I purchased over this year. And so the defense provides a letter, which is Defendant's Exhibit C, which is a registration, I guess, showing that the car wasn't properly registered. Well, people drive on cars that aren't registered and uninsured every day. And where were you on the time of day? His own attorney asked, where were you on this time of day? More than likely, I was at home in the bed. Yes, I was at home in the bed. I'm not sure. Defendant then said, I work the midnight shift. I get off in enough time to take my minor children to school. And once I take them to school, I return home and I go to sleep until it's time to pick them up. Yes, and that means you will be available at around the time this happened, which was 9-something in the morning. I believe it was 9:27 on the timestamp, around the same time that the victim in this case drops off her children and is available at Dunkin' Donuts. In addition, Mr. Williams Bay said he was at home in the bed. I'm not exactly sure how they would be distinguished from any other day. If that's what your normal practice is to get off work and go home and get in the bed, then okay, you do that every day. I don't know how all of a sudden you remember on 12/2/2018 or December 12th, 2018 that you were at home in the bed, but there's no alibi there as to you doing anything. There's no time sheets or anything to say you were someplace else. So allegedly you were home and in the bed. Then the court receives a picture. Defendant's Exhibit A is supposed to be the defendant's Mercedes-Benz, and the defendant's Exhibit B is supposed to be the shot from the video going into the Dunkin' Donuts parking lot, which is the same exhibit that was produced by people. They also produced still shots of this Mercedes-Benz going into the Dunkin' Donuts, which was People's Exhibit number 2 and 3. Now, Mr. Williams Bay says, well, this is not his vehicle because you can tell these are after factory vehicles, I believe, or aftermarket vehicles, something like that. Some kind of vehicle, tires, I'm sorry, that he indicates he would never put on his car. I am not convinced of that. This case pretty much comes down to credibility and whatever evidence that the court has to support what the individuals are saying. And mostly in these cases, it is a he said, she said. And that is pretty much what it is in this case. However, the evidence that I have here overwhelmingly supports the victim's account of what happened and not Mr. Williams Bay's account of what happened. First, what the prosecutor has to prove is the defendant committed 2 or more willful, separate, non-continuous acts of unconsented contact with Ms. Sydney Taylor. The court finds that the People's Exhibits 7, 8, and 9 indicate that those were different contacts at different times during the time that the PPO was in place, which was People's Exhibit 1, which was served on the defendant on July 2nd, 2018, and did not expire until December 31st of 2018. And those text messages, 3 of them, different times were received. In addition, the court also believes that that was Mr. Williams Bay that went into Dunkin' Donuts and called the victim in order to harass her or intimidate her. Second, that the contact will cause a reasonable individual to suffer emotional distress. The court finds that it would. These individuals clearly have an antagonistic relationship. It was very evident from what they said when they took the bench and the stand. This happened in 2018, and the victim managed to be here. Many times they don't. In 2021 and 2022, and be here to watch these proceedings every time. So it's very clear that she has suffered some emotional distress with respect to this incident. Third, that the contact caused Whitney Taylor to suffer emotional distress. I just dealt with that. Fourth, that the contact will cause a reasonable individual to feel terrorized, frightened, intimidated, threatened, or harassed. In this case, I find that it would cause a reasonable person to be intimidated or threatened or harassed. And it definitely would cause Miss Sydney Taylor those same things to be threatened or harassed. And six, that the stalking was committed in violation of restraining order, which the defendant had actual notice of. The defendant was served personally on July 2nd, 2018 by a sheriff who's indicated he served him. The defendant himself is admitted to knowing that there were PPOs, just not knowing which ones. Although he claims he was not served on the day, he couldn't give any explanation as to where he was on that day. And during that time of that PPO, there were numerous text messages received, as I've indicated, as well as the court finds that he was at the Dunkin' Donuts on December 2nd, 2018. Mr. Williams, please stand. The court finds that you are guilty as charged to the count of stalking, aggravated, and habitual third offense notice as well. All right, that's the court's decision.
Thank you very much, Your Honor. Will you be coming back for sentencing?
Yes, we will. All right, let's get a sentencing date. July 20th. July 20th.
Unfortunately, Your Honor, that's a bad date for me. That week I am out of town for an anniversary trip with my spouse.
That's fine. Let's get another day. Which one? 12th of July? Yeah. July 12th?
Works for the people.
All right, Mr. Williams Bay, glad to be here on July the 12th in person.
Yeah, Honor, I will not be there in the court. I'm sorry. I am out of town from July 2nd to July 23rd. So it's 25th. I'm 3 weeks of July out of town. Can we have some
August 1st.
August 1st? Let me
double check my calendar briefly, Your Honor. My apologies. September, I was getting ahead too far. Your Honor, I am set to begin a jury trial that day in another court. If we can do it first thing in the morning, perhaps
Yes.
I could do it. Maybe at 8:30 if Your Honor's on the bench that early.
No, we can do it at 9 o'clock.
Okay, I'll make it a first thing that day.
Mr. Williams Bay, make sure you're on time. Please don't let me have to find you, Mr. Williams Bay. I'm leaving you out before the sentencing, and I'm not requiring a tether. So make sure that you are here. Okay? Well, see, you've been late numerous times. I mean, you end up having to go in the back one time because you were late, correct? Yes. Pardon me?
Unfortunately, I do follow that.
Okay. All right. So we will be back here at 9 o'clock on August the 1st sharp, since we have to deal with this because Mr. Keening has a jury trial. And we have to get a pre-sentence investigation report done. So Mr. Williams Bay, you're gonna have to call probation. Give him the number, Madam Clerk. Yeah, but he doesn't have anything right with, so give him the number. That report has to be done.
Does Your Honor, does the court require an investigator's report from me, as we would with the plea?
Madam Clerk, do you need the investigator's report?
Yes.
Ms. Hollis,
You said a charge that I didn't honestly, you need to also One charge, the judge said two.
She
No.
found habitual.
No, I said habitual. That's not a charge, that's a notice.
That's it.
It's on the information, but the MCL number.
Yeah, the old information and in
Oh, you
addition
mean-
to amending the information, all prosecutors calling that up, man, honestly. It still says one thing in our.
It is. Only thing he changed was the time span. The original stuff is still the same. It's on his information. Stalking aggravated is the first one, then it says habitual third offense notice. That is on his amended information.
And that was on every information filed in the case. I don't know, I don't have any access to amend information.
Well,
Okay.
I don't know how to get it changed, honestly. All I'm telling you is that's what's on the amended information.
Okay, I'll add it, they're gonna send it up, it's not, it doesn't match.
Well, Ms. Hollis, I will send you an investigator's report for referral for the PSI.
Okay.
You might need to go to the typist and make sure it's in honesty correct.
I can check with Ms. Lloyd, who's in charge.
Yeah, just check with them and we'll just make sure it's correct. It's not a big deal. You can handle that.
Yeah,
Okay?
they're gonna contact him.
Okay. All right, so we'll see everybody back on August 1st at 9 o'clock.
Very well, Your Honor. Thank you very much.
All right, did you give the number to Mr. Williams?
I did.
All right, you have to call them today, get set up for a pre-sentence investigation report, Mr. Williams. I do not want everybody leaving at the same time. So,
I will email. you
Mr.
when I'm back
Williams
to my
Bay,
office.
Miss, Vic, yes, go in the room over there, and Mr. Williams Bay,
Necessarily, so I'm gonna
exit the
speak to
location.
Ms. Taylor while Mr. Bailey.
Yes. All right, hold on, let me have the victim. Mr. Williams Bay, while you are out, please do not contact the victim in any way. Don't have a third person contact her, don't text her, don't email her, don't show up anywhere near her. Okay? Okay, well then that's it. I just want to make sure that it's on the record. You are gonna have no contact. All right. Thank you. All right, thank you. This matter is concluded. Right. Tell him not to leave yet. Ask Mr. King. Ask Mr.
Derek,
Is what?
Derek,
Derek Dugan?
Yep.
Okay.
parties on Derek Dugan, please. This is
Yes.
case number 2248. People of the state of Michigan versus Derek Dugan, scheduled pretrial appearances for the record, please.
Good afternoon, Your Honor. Michael Tenier for the people.
Yes, good morning, Your Honor. Joseph Dillard, P 37225, on behalf of Mr. Dugan. We consent to this matter being conducted on Zoom.
All righty, Mr. Dugan, state your name for the record.
My name Derek Dugan.
All right, good morning, Mr. Dugan. Dugan and
Good
Mr.
morning, Your
Dugan.
Honor.
All right, what are we doing today? This has been resolved by, well, this is 22.
Your Honor, Attorney Joe Dillard, with respect to this matter, I got a copy of medical records, or at least part of them. Yesterday, I had a chance to look at my email very late at night, haven't had a chance to diagnose everything fully. I would like to have these medical records referred to an expert. And so I'm going to have to see if I can locate someone to analyze it. I did not get copies of the x-rays with the discovery that came from the hospital. And so I would be asking for the x-rays as well.
Well, I'm assuming Mr. Tenney submitted a subpoena to the hospital, and that's.
I did, Judge, and that's they gave the reports back. They didn't send the actual images, which is fairly typical in these things. I rarely, if ever, see the actual images come through with medical records. Usually it's the actual written report with the doctor's notes and diagnoses and so on, which is what was provided.
All right, so you plan on getting somebody to look at these records for you? Is that
Well,
correct?
it's not as simple. It's not just looking at records. It's actually looking at the images as well. And so this is like 50% of what I'm requesting.
Well, Mr. Dillard, if you have the report from the images, then you still have the information. So whoever you get, which I'm assuming will be a medical person, they will know what all of that means. So right now, no, I'm not finished talking. Please don't talk over me. So what I'm indicating now is, you just indicated you want to get an expert, which I'm assuming is some type of doctor, to look at the medical records that you received. Is that correct?
And images, Your Honor, as well.
All right. How long is it going to take you to get this person, Mr. Dillard?
I'm going to have to shop around. I'm not certain. I would hope to have a name by early next week and go from there.
All right. Well, why don't you get the person first? Because you're not the medical person. And maybe
Correct.
that person can look at the notes and they don't need to see the images. So why don't we leave it up to that person first?
Okay.
So, all right. So let's I'll give you an opportunity to get it to 22, not a 21. So I'll give you some time on this. Just give me some time and whatever the next good date is. It's not July the 5th.
Your Honor, that is not a good day for me.
July 6th?
I'm going to be coming off. I'm going to be in the middle of a trial, and after that event is going to be right around my anniversary. Could we get it in the week of maybe the 12th or the 13th or the 15th?
July 13th. July 13th.
Okay, and that's going to be for review?
we're gonna be here on a pre-trial. You need to indicate to the court who you have that has reviewed these records. And we need to make sure so we can move on, since that's what we're waiting on. Everything else has been handled in this case. Is that correct?
Correct, Judge. The issues with the police video, those were also sent to Mr. Dillard. That was back on May 6th. Was a report from Robin Rogers of Detroit Police showing that the videos are not available.
And did they indicate why the videos are not available?
Open it back up. Writer searched WatchGuard database for body cam videos of officer, in this case, Honeycutt, badge 887. Maxon, also searched for scout car driven by the officer Honeycutt and Maxon, request date upon reviewing WatchGuard system. Writer found there was no video available for this request. Please see screenshot of images, and there's attached where it shows the search function and all that, and nothing is being brought up for that date for those officers. So it doesn't say specifically why, just that they are not available.
All right, so, this is not a police issue, really. So whatever officers responded after the fact. I'm taking it after the incident, correct?
That's correct. This was a assault of crime, so they showed up after they were called to it.
All right, so the only reason, Mr. Dillard, you have to find out whether this request was made too late. I mean, this was back in 2020. If we're just now asking for the video, it's probably been taped over, or was it malfunctioning? I mean, that information you can have the police provide as to why there is no video, and that can be dealt with at trial. Who is the officer in charge of this case, Mr. Penny?
It's Officer Shane Pringle, Pringle.
All right, so Mr. Dillard, maybe you should give him a call. I'm sure Mr. Tenney has his contact information to find out why there is no video. Was it the fact that it was some video, but it wasn't requested in time? Or were the cameras not working at all on that day? I mean, I think that's important to know if you're going to trial. Mr. Dillard, you're muted.
Yeah, and I made my request for discovery shortly after I was appointed. I made a request on the 5th. I was appointed on the 4th.
The 5th and 4th of what, Mr. Dillard?
I'm sorry, of October of 2021.
All right, well, Mr. Dillard, this incident took place in 2020. So
Again,
it was, by the time you got to the case, it was a year old already. So
Yana, but if I can state that there's a statute that indicates that if they're prosecuting the case, those all records and recordings should be kept, and just randomly saying we have a policy running. Go ahead, Yana. Yes, Yana.
Preaching to the choir. I already know that. But what I'm saying to you is call the officer in charge to find out why. Was it just not kept and then you got an issue? Or is it that it was malfunctioning? If it was malfunctioning, there never was a video. There's no need of you saying that to me. All you're doing is taking up time on my docket right now. You need to talk to the officer in charge as to what happened to the video. Okay?
Thank you, Yana.
All right. Anything else with respect to discovery?
Yana, at this time, I was prepared to come here today to, as it related to the medical records, and as I indicated, I got them yesterday, so I'm ready to proceed with that. If something else should come up, at that I'll address it.
Okay. Well, when we come back on July 13th, you should have gotten your person and talked to them by now. Whatever offer there is needs to be put on the record again on the 13th. And we need to know what we're doing. If we are proceeding the trial or if we're taking a plea in this matter. Okay?
Thank you, Yana. But if I'm still dealing with the medical issue, I would just ask for the court to be fair in terms of whatever may be the direction that this case goes at that point.
Mr. Dillon, I'll deal with that once you get a medical person. You're making something an issue. That's not an issue right now. We
Thank
don't
you,
know if
Anna.
the person is gonna have an issue with not having the images. Okay?
I appreciate it.
All right, we'll see you back on July 13th. You should have your person by there and by then and know what you're doing. All right, this matter is concluded.
Thank you, Anna.
Thank you.
Thank you, Your Honor.
And that's going to be at what time, Yana?
9:30. All right, Mr. Duggan, we'll see you, or Dugan, we'll see you back on July 13th at 9:30.
Yes, thank you, Your Honor.
You're welcome. This matter is concluded. All right.
We're ready on the other matter, Yana, that I have is 2 cases with Mr. Rico Valentine.
Okay, Mr. Rico Brown.
You want me to leave?
All right. Yes, you can hang up, Mr. Dugan.
Okay, thank you, Your Honor.
Our Valentine is a sentencing, right? Yes. All right, we're ready.
Recalling case.
Oh, man, you leave.
These are case numbers 22401 and 419. Both people of the state of Michigan versus Rico Valentine, both scheduled sentencing appearances again for the rest of the week.
Good afternoon, Your Honor. Michael Tanya for the people.
Joseph Dillard, P37225, on behalf of Mr. Rico Valentine.
All right, Mr. Rico Valentine, state your name for the record.
Rico Valentine.
All right, did you say you couldn't get your camera to work? All right, there you go. All right, very good, because you're in court, so you need your camera on. All right, Mr. Valentine, you consent to be sentenced over Zoom? Mr. Valentine? Mr. Valentine, can you hear the court? Mr. Dillard, I don't know what's going on with your client. I think it's he's frozen.
Okay, Mr. Valentine, go to the top of your phone or to the lower part. Do you see a microphone where you can turn it on or off?
My mic is on.
Okay,
All right.
good. You're heard now.
For a second. Never mind, that's okay. All right, Mr. Valentine, do you consent to be sentenced over Zoom?
Yes.
All right, let's start with the people. Have you had an opportunity to review the pre-sentence investigation report?
Yes, Judge.
Are there any deletions, corrections, or additions?
None for the people, Judge.
All right, defense, any deletions, corrections, or additions?
Yes, Your Honor.
Okay, where?
When you go to current convictions, the general cover sheet that they have as to the first case ending in 402, it has 0 credit days, and it should be 4. Now, if you go to the page 2 of that report, Department of Corrections recommendation page, it has 3 days credit from September 6 to September 9. And from those September 6 to September 9 is 4 days credit. So I would ask that be correct, that be changed.
Jail credit should be 4 days instead of 3 on case number 419 and case 402. Is that correct?
No, that's on case 402, 220000402 is the 4 days.
Okay.
As to the case 22-000419, which is the case that came out of Westland, that case has 3 days credit. And in speaking with my client, he indicates that he was in custody from December 23 of 2021 to January 6th of 2022. That would be a jail credit of 15 days on that case.
Ms. Shawn,
Yeah,
can you, check the jail credit as the case number 22-41901 regarding Mr. Rico Valentine?
yes.
Thank you. All right, go ahead, Mr. Dillard. Anything else?
Yes, Your Honor.
Okay. Go ahead.
Okay, with respect to the case that was in Detroit, that's the 22-0040201F. With the matter on Lafayette, in terms of the OV,
We haven't gotten to guidelines yet, Mr. Dillard. I'm asking about the body of the report. Any other
Okay.
changes to the body of the report?
okay, in terms of the body of the report, there's no additional changes. Is that correct, Mr. Valentine?
Yes, that's correct.
Okay,
All right, Mr. Valentine, you had an opportunity to review the pre-sentence investigation report with your attorney?
Yes,
And outside of the jail credit, which we're looking into, everything else in the case is true and accurate?
yes.
All right, Mr. Tenney, anything you'd like to say before the court imposes a sentence?
Judge, it sounds like Mr. Dillard wanted to go over guidelines.
yes,
All right, guidelines are for case number 402, are 0 to 3.
402, Your Honor. The
0 to
matter, I'm sorry?
The guidelines are 0 to 3 on 402. Is your issue with 402 or 419? You're muted, Mr. Dillard.
I don't know how this mic keeps turning off. I'm concerned at this point, we're directing you to the 402 case, the Lafayette case. It's not going to be a change in the numbers. The numbers are going to be.
Mr. Dillard, we gotta just get to the point. What is the change, Mr. Dillard, on PRV? Any changes? Yes or no?
Yes, the OV1.
one?
OV1,
OV1 should be what?
0
Instead of 5
instead of 5.
on the 402 case. Mr. Tenney, your response.
No objection to that. I do have a change to PRV 7.
All right, court will change OV1 to 0. So I take it the PRVs are all 0 and that's correct, correct?
Judge, PRV 7 should be scored at 10 points since he picked up the 419 case. That's a subsequent felony.
All right, court will change number 7 to 10.
That changes it to PRV level of C as in Charlie.
All right, you see that defense?
I'm listening.
Any objection?
With respect to the
PRV 7, Mr. Dillard? Any objection, yes or no?
yes, Your Honor, I have that at 0.
What's the objection? It doesn't matter what you have it at. What's the
Yeah.
objection? There's another case that makes it a 10 and not a 0. So how are you objecting?
Your Honor, could I just, I just got all of this stuff and so.
But Mr. Dillard, you should be ready. You should be ready. This is taking way too long. What is the objection? There is another case. He has another issue. How is it not 10? You're muted. You're still muted.
Yeah, no, I'm here. If I can just have 1 minute, Your Honor.
Oh my God. Mr. Tenney, anything on the OBs?
The OVs, no. Assuming that Mr. Dillard doesn't have an objection, or if the court were to say it is 10 points, it would make it a C1 cell. That'd be 0 to 9.
All right, it's 10 points, because he has another subsequent or concurrent, case. So, 10 for the PRVs, 0 for the OBs. That's a C1, it's 0 to 9. If you have an objection, Mr. Dillard, you need to tell me what it is, because clearly he has another case. We're dealing with two right here.
No, I understand, Your Honor.
All right, so now on to 419, it's the same thing. PRV 7 should be 10, is that correct?
No, Judge, that one will be 0. The PRV 6 is accurately scored at 10, so that's correct in my eyes.
Okay, so PRV is on still 10, it's still a level C. OB, do you want OB1 should still be 0 and not 5?
I have no objection to that, Judge.
Okay, we're gonna change OB1 to 0. That changes the OB level 0, makes it 1. Again, a C1 is 0 to 9, which they already have anyway. Okay. 0 to 9, he's still probationable. Anything else, Mr. Tenney, before we record it?
Judge, these were your Cobb's evaluations, so leave it to your discretion at this time.
All right, Ms. Shawn, do we have a jail credit yet for case number 419?
I have 15 days.
15 days is what it's about to be. All right, 419 is changed to 15 days. Okay, Mr. Dillard, anything that you'd like to say on behalf of your client before the court imposes a sentence?
Your Honor, my client is remorseful over these situations. I would ask that the court adopt the recommendation of the Cobb's evaluation and assign him to HIDA.
All right, Mr. Valentine, anything you'd like to say before the court imposes a sentence? You're muted, Mr. Valentine.
I said no, ma'am.
All right, Mr. Valentine, I gave you a Cobb for 2 years probation under HIDA, Home Use Youth Training Act, which is an opportunity for you not to have a criminal record if you are successful during your probation period. And I hope you understand how important that is. So your cases will run concurrent to one another. It is 2 years probation. You must not use any object as a weapon. You must not own, use, or have under your control, air control, weapon of any type or any imitation of a weapon. You must not be in the company of anyone you know that possesses these items. You must make genuine efforts to find and maintain legitimate employment of a minimum of 30 hours per week. Mr. Valentine, did you get your high school diploma or GED?
Yes, I have my high school diploma.
Okay, and what are you doing right now, Mr. Valentine?
I'm really looking for employment right now.
Okay, all right, and you live with your mother?
I live with my auntie.
Okay, well, you're old enough now to have a job, Mr. Valentine, or still be in school. Do you live in the city of Detroit?
Yes.
All right, I'm about to give you a number for Detroit at Works. It helps people find jobs. It will pay them to train them. So they have a lot of money to use. You have something to take this number down?
Yes.
Are you ready? 313.
Yes. All right.
962 9675. Repeat that number back to me, Mr. Valentine.
313-962-9675.
That is correct. All right, I want you to call them. That's Detroit at Works. Tell them that you're on probation to my court, Baker Robinson, and I informed them that you needed to contact them to try to find employment because you have to get employed at least 30 hours per week. And once you get employed, you have to provide verification of that employment. And you can't give any reason to be terminated or voluntarily terminate that employment unless you first obtain written permission from the field agent. There are certain costs I cannot waive, $68 state cost, and $130 crime victims assessment. And pursuant to statute, is $30 per month for supervision fee. There are court costs in the amount of $1,300. So what I'm going to do, Mr. Valentine, do you drive, Mr. Valentine?
No, not right now.
All right, you know how to drive, correct?
Yes.
Okay. I am going to waive your court cost, the $1,300, but you will have to do 20 hours of community service. You got the term of probation to get it done. You can do it if you go to a church, you can do it there. If you work, if you want to go to an animal shelter or do Meals on Wheels, do something with your mom, it doesn't matter. But you have to get some 20 hours of community service done in lieu of $1,300, okay?
All right.
You have the term of probation to do that, which is 2 years. Mr. Dillard, you are appointed, is that correct?
Yes, Your Honor.
All right, so there's $400 in attorney fees. You're not working right now, so I am going to reduce those to 200, but you have 2 years to pay $200. There's 15 days jail credit on the 419 and 4 days jail credit on the 402. With respect to case number 22419, I'm also allowing you to be on HIDA, 2 years probation, run concurrent with the other case. Same thing, you have fine employment. I'm going to waive the cost on this case because you're already paying on the other case. So I am waiving all of these costs except for the $68 state cost. Everything else has been waived. All right. Crime victims cannot be waived, so I have to give you the $130 crime victims. They don't even have it on here. Oh, yes, they do. Crime victims cannot be waived, so that's correct. But I waived the attorney fees and the court costs. All right, Mr. Valentine, you need to call probation when we hang up from here today, so you can let them know you've been sentenced and get set up. The probation number is 313-224-2600, the same number you called to get your sentence report done. You have to let them know you've been sentenced. Mr. Valentine, I want to see you back in 3 months because I want to know that you are employed. Okay, Mr. Valentine?
Yes, ma'am.
I want you to come back on September the, hold on one second. September the 13th is your review date. Your attorney does not need to be here. You just need to log on and let the court know that you are employed. I want you to stay out of trouble. I don't want you to be back here, okay, Mr. Valentine?
Yes, ma'am.
All right, and if your crowd is getting in trouble, I suggest you change crowd. All right?
All right.
All right, see you back in September. This matter is concluded.
There, Your Honor.
Thank you. Are we done? Yeah. Wait a minute, Antoine Bowman.
That's the one that, that was, that's Judge Boykin.
Oh, that's Boykin? Oh, thank you.
Unless you want to do it.
No.
That's my present for today.
What happened? It's not going?
No.
Why not?
I
Does
don't
Judge
care.
Boykin know that?
Yeah.
Why isn't it going?
I don't know. I just know it.
Oh, okay.
I know.
I signed the wrong place.
All right, Judge, I think that's everything. So
All
I'll
right,
see
our
everyone
docket
tomorrow.
is done. Our docket is done today. Tomorrow is the jury trial. Mr. Tenney, are you on this jury trial?
I'm on both of them that are set for tomorrow.
Oh, fun. We're gonna have fun.
Did you receive the email, Mr. Tenney?
Which one? Just now?
About, Barry and Pruitt?
Brandon Pruitt's not mine.
Yeah, that's not his.
Oh, okay. What trial he on then?
He is on number 2 for tomorrow.
I'm on Alta Mimi and then also Corey Kirksey.
I feel a little feverish.
All right. Now
Oh, yeah? Oh, yeah? I see how it is.
Who is Savannah Flores?
I don't know. Let me ask. Miss Flores?
All right, I'll see everyone tomorrow. Have a good night.
Hi, Miss Kenny.
Miss Savannah Flores, please unmute. Have a good day, Miss Flores.